Lordships kindly. My
Lord, this is a
my lord, this matter was ought to be listed yesterday, my lord. What has happened before trial court is listed tomorrow for an argument.
Today I'm raising at 12:30.
It's therefore request the end of list or Monday, please, my lord.
What is urgency?
My lord, the urgency, my lord, in this case, at the stage of final hearing, my lord, the defendants filed, my lord, registered will.
Oh, you're saying something
My lord,
about matter list.
it was listed yesterday before the learned trial judge, my lord, and thereafter is posted tomorrow, finally for arguments without any other liberty given.
When did you file the writ petition?
Monday, my lord. On this Monday, my lord. That was on 27th, my lord.
It was not listed.
No, it was listed, my lord, on maintainability day before yesterday. Your lordship overruled maintainability and listed yesterday, my lord.
Monday.
Oblige, please.
I'll hear. Yes.
The attachment of mobiles has been issued by.
When was the writ petition filed?
Writ petition was filed day before yesterday, Your Lordship, and yesterday we have complied all the office objections. Though we have deposited the entire amount before this honorable court, Your Lordship, there was some mistaking from the account section of this honorable court in sending that matter, Your Lordship, without giving us an opportunity.
Monday.
Your Lordship, tomorrow it is posted for attachment of mobiles, Your Lordship.
I'm telling you, I have to complete the list and I'm
Only
raising
one-
at 12:30.
Only one minute, Your Lordship. Even this honorable court has passed the order noting that there is a mistake.
When was the order passed?
Pardon, Your Lordship.
When was the order passed?
On 14/7 itself, attachment order has been passed and from the Hassan, they have sent the file and immediately I have filed it, Your Lordship.
So you people can take 10 days, 15 days in transit, but High Court should hear it immediately the next day, even before you file today afternoon. By today evening, it should be heard.
My apologies for that, Your Lordship. Due to some administrative, this thing it has happened.
Yes.
My lords.
All that, why should you mention further? Give it to the court officer, it will come. Just wait. Huh? Take it.
Previous memo I have not mentioned in detail memo. That's why I am using in detail in this memo.
And please don't mention any memos, only what, any urgency
Urgency,
for
my lord.
today.
My lords, BESCOM is threatening to.
Previous memo I have not mentioned in detail.
My lords, with your permission, if I may
threatening
mention a
to
matter.
disconnect electricity, my lords, by the end of this week. Therefore, I'm seeking a listing at the end of the list today, my lord.
File it.
I filed it this morning, my lords. They came to my office yesterday, my lords. I employ around 200 individuals. I manufacture batteries and battery chargers. I need electricity, my lords, to function.
When did you receive that communication?
27th, I received the communication, my lords. I filed it this morning, my lords, by end of list.
No, I think I can't go to Dharwad now,
My lords.
completing all this. Yes, end of the list.
But it's a part-heard matter. Pursuant to your lordship direction, I paid 1.96 crores along with interest. They have not released the documents and they filed an IA for clarification.
Every day. I think your client should pay at least 10 lakhs to the High Court registry for every time listing your
They
matters.
filed an IA for I filed contempt, my lord. They filed an IA for clarification. I filed objection that might anytime next week, my lord. Request.
For that, you don't have to mention, give it to the court officer, the memo. Yes,
My lords.
only matters at tooth, anything urgent that has to be taken up, please make a mention.
My lord,
Yes.
1997 suit.
No, is it supposed to be taken at today?
No.
Give it to the court officer.
my
I'll
lord,
look
the
into it.
urgency
My
for
matter, my lord, any day next week, my lord,
Give
because
it to the court officer.
obliged.
Kindly, any day,
my lord, urgency for today, my lord. Urgency for today is the
Next week, any day.
CPC matter, my lord. The impugned order was passed on 28th.
Any day.
It is posted for final arguments today itself, my lord. An application to recall the witness was filed. Earlier it was rejected because on the very same day the trial judge insisted on cross-examination. Then I filed a recall application, made a submission that it could be taken up on any day for cross-examination. That application is rejected on 28th. It is posted today for final arguments. I filed the writ petition yesterday.
My lords,
Seeking end of the
this
list.
matter, my lords, in this petitioners are senior citizens due to the impugned
Give it to
order.
the court officer, yes.
Your lordship, the execution case on Monday, attachment warrant issued and executed also. The amount deposited in already in court, they are taking in on Monday kindly, today only 2:30, my lord.
I'll take it up on Monday also. Why
Monday.
2:30 today? Yes. Yes, Mr. Counsel?
May I make a
Achha,
mention, my
please.
lords, serial number 42 in the days list, my lords. matters being listed for dismissal on the ground of maintainability. The law is settled. The same order is challenged by the other defendant also. That petition is admitted. My lords, may only request it be called along with the other petition, my lords.
What is that number? Give it to the court officer. List
That's
along with,
13440 of
list along with,
2002.
you are a petitioner or respondent in this?
I am petitioner in this petition and respondent in that. My lords.
Any interim order?
No, my lords.
Yes, list along with so and so.
Yes.
Yes, Mr. Arjun.
Much obliged, my lords. My lords, this is for Monday. It's a fresh writ petition we filed on 23rd. Defects were cleared on 29th. There is a similar matter already coming up on Monday.
If
My
it is cleared, it will come. Yes, call the list.
Much
My lords.
obliged, my lords.
Dismissed. That petition is allowed. The application filed with the petition for withdrawal of the amount is consequently allowed. The adjudication concerning the remaining amount claimed in the execution petition shall be processed independently on its own merits.
Please.
Notice has, hand summons has been served, my lord, to the trial court counsel, for which I have produced, I have filed the memo stating that for having served the hand summons to the trial court advocates.
To respondent number 127
Yes, my lord.
and all 7, 8 and 9.
Yes, my lord.
The memo, as it is submitted that as per the order passed by this court, the petitioner has served the hand summons on the counsel appearing with the respondents 1 to 9. And in that regard, a memo is filed. Memo is taken on record and the notice to respondents is self-sufficient. Yes.
Interim order, my lordship, because of the matter is posted for evidence. The court has no jurisdiction to try the matters because the earlier suit already has been compromised, wherein the defendant has participated.
Actually, in CRPs, if I order notice, already 50% I am not convinced, then only I'll order notice. Now, if I hear this matter today, unnecessarily I'll be dismissed. You are seeking an order of dismissal. So I'll hear it on some other day.
Please. The meanwhile,
Yes,
my
this
lord,
notice to the respondent is self-sufficient. This is matter on 18th of August. Yes.
But for the petitioner, my lord,
Yes.
7, 10 and 13, may I seek, my lord, your lordship's kind permission to serve on the council, my lord, representing them before the trial court, my
Yes,
lord.
petition is permitted to serve.
Make submission.
Uh.
They are not necessary so far this petition.
Those responding 7, 10 and 13 are not necessary for this petition. I am the contesting respondent.
They have an interim order.
Interim order is against me, my lord, that's the thing. They intentionally
I am
made
ready,
them
my
as
lord.
party. They are all,
I am
they-
ready,
they-
my lord,
before
immediately, your
in the report, they are together appearing.
Do one thing, I'll give a date. On the day I'll take. In the meantime, let them serve. Even if they don't serve also, I'll hear it on that day.
Much. They
Please,
shout
please,
it.
I'm ready, my lord. Whatever date your lordship.
This is matter on 11th of August. The petitioner served the hand summons on respondent number 7, 10 and 13. The learned counsel, the respondent submits that the interim order is against, operating against the petitioner and they are not the necessary parties for this application. List this matter on 11th. On the day whether the notices of hand summons are served on the other respondents or not, petitioner shall argue the matter on the merits of it.
Much.
My lord, the interim order may kindly be extended, my lord.
Interim order earlier granted is extended. Yes.
I'm grateful.
My lords, the office objection, my lords, is regarding not making a original party, my lords, in the suit to the plaintiff was not originally made as a party in the present writ petition. I have filed impleading IA, my lords.
No only received
That
a
IA
copy,
may
my
be
lords.
allowed.
No only received.
Impleading them, you filed a writ petition.
My lords, what has happened is a trust, my lords, has filed a suit. The person who is representing the trustee has no locus standi to represent.
Yeah, but when you're filing a writ petition.
Certainly, my lords. I had written, my lords, an office note. My lords, the last occasion, your lordship directed me to file an IA. I have filed an IA, but the office has not put up the IA, my lords, which was filed. That is why, my lords, it has come on now.
You have an interim order.
I have an interim order. I have filed the IA. My lords, in fact, IA.
Without making the necessary parties to the writ
My lords, they were
petition,
caveators.
You take an interim order.
My lords, that is not so, my lords. That is why, my lords. They were caveators. They were heard and interim order was granted. It is not, my lords, an
Is it?
ex parte order.
My lords, there are 4 matters, out of which in one matter they don't have an interim order.
In
And
all
with
matters,
respect-
there are interim orders, my lords.
Letter.
Please.
And also, my lords, it was heard on merits. This has been going on for the last 1 year. What is happening is their main contention is this person could not represent the trust. However, the trust is a necessary party. I am not very sure whether in the other matters he has made the trust a party or not.
Give the numbers.
All the
connected.
matters are listed
Connected
before your
and
lordship.
listed together.
Your lordship may kindly fix a date for argument. We will argue the matter.
You know, the registry is directed to, first of all, we have to impede the trust.
Please,
I
my
have filed
lordship.
IA, my lords, on 10th of July.
Council of the petitioner submits that he has filed an IA seeking impediment of the trust. Is there? Look at it. In all the matters it is put up. In others, you have not filed.
My lords, in others, my lords, I had written a my lords note that has been accepted by this honorable court, my lords, hence it was not made as a party. Only in this, my lords,
Please make it. How
please,
can
my lords,
it
I will
be?
make, my lords, in all the petitions. filed
IA 1 of 2026 is filed to impede the, what is this? Impede the Devara.
October Rukmini by Deva Bandaram.
Upma by Devara Bandaram. The notice, anyone of you accept notice to?
No, my lords. They
No?
cannot, my lords, because
My lords,
there is a
I
dispute
am-
regarding who can represent the trust.
My
That
lords,
is,
Ever
notice
representing
may have
before
to
the
go.
trial court, whoever is representing, they will take.
caveat has also been filed on behalf of the trust, represented by the present respondent.
So and so accepts notice on behalf of the trust. The petition shall file similar applications in the other two writ petitions. List these matters for hearing on 12th of August.
Interim orders may be extended, my lords. in all.
Interim order earlier granted is extended.
Great, in all the matters.
Huh? Huh? IA is allowed.
In all the matters. In all the matters.
All the matters interim order extended. In 5.2 and 3, you have to file the IA
Please, my lords, I will.
by the next date of hearing.
Please, before that I will file it.
Yes.
Great.
Much okay.
Yes, sir, for petitioner. Respond number 13 died. I will file necessary application before the registry and tomorrow, my lords.
Let's have a submission in this, my lords.
No, it's a writ petition of 2025. When did this respondent die?
A respondent died.
2021 itself, my lords.
Before the trial court, they have not made parties. As per the plaint, I have pleaded in the writ petition, my lordship.
It have been the duty of the
Rec-
plaintiff to make a,
Recently, we find out the details of the respond number 13 and the death certificate.
Come to the plaint. What is it you are submitting? Come to the plaint in the suit.
Right copy, we are not produced. Page number 24 to 35.
Page number?
24, my lords.
Which respondent is that before the trial court? Respondent number? There are only 10
Nine.
respondents.
9, my lords. Defendant number 9 is respondent number 13 in the writ petition.
No.
Subsequently, they got implemented, I think.
Who? This 13th respondent.
Yes. Respond number 13, 14. Initially, the plaintiff, original plaintiff has filed suit against the non-joined up. Subsequently, the other defendants have got implicated in this suit, my lords.
But even apart from this, my lords, what has happened here is respondent number 13, after she passed away, her husband has sold the property in favor of Balaji and her wife Manjula. And now what has happened, my lords, the very petitioner herein, she claims that the property is farmland and she is in possession of the property, and the property has been sold by her father in favor of respondent number 1 here, to which she has filed an to which she has filed a suit for declaration and injunction. My lords, when the property was sold by respondent number 13's
So
husband,
what is the present IA?
well, it has been posted for judgment on
What is the IA?
to appoint
Appointment
the
of
court
commissioner.
commissioner to identify whether the property is still intact with respect to the farmland or whether the sites have been formed. That's the sale deeds which I request your lordship to see, my lords.
No, you are going into the merits of the matter. Now
Please.
we are on the point. What about this 13th respondent? She's a necessary party to this.
Yes, my lordship.
Not
She
a
was,
necessary party for the reason that, my lords, her husband has sold the property in favor of Manjula and Balaji now.
They are on record.
They are not on record, my lords.
Then who will protect their interest?
They should have been brought on record, my lords. They have not been brought on record.
And you file a writ petition against the person who died and obtain orders.
I am not the advocate for trial court. I have filed a writ
And
petition
moreover,
about-
my lords,
This matter pertains to the.
That you should be a trial court advocate.
let's have one more submission.
I will
my
take
lords.
necessary instructions and
Not
file.
necessary introduction.
We'll file necessary application on tomorrow itself, man.
Suit of 2009, appointment of advocate commissioner, stay is operating from the last 1 year.
That's a one more submission, my lords. The petitioner herein, when the property was sold by respondent number 13's husband in favor of Manjula and Balaji, she has been the witness, my lords. That means she indirectly agrees that the properties are site and not the farmland. for which he files an application before the trial court saying that to appoint a court commissioner to identify.
This matter on Tuesday, by the time an application to bring the LRs or is not filed before the court, the stay granted by this court stands vacated without any further reference to the court. If the petition IA is filed, list the matter on 4th of August.
Please, sir. Oblige.
Interim order earlier granted is extended.
Much.
Petitioner, my lord. My lord, we were supposed to pay 10 crores. Kindly out on 6 months will be paid. Registration.
I will vacate the order.
One submission, because my lord, the order was released on 3rd July, my lord, because it was, they said some correction was there. That is a 10 days.
Where are we now?
No, my lord, what has happened?
You were there in the court, isn't it?
Yes, my lord, the correction was supposed to happen. We could not get the order in time. And registration.
What is necessary for you to take the
I need
order?
to say 2 flats, one is sold, my lord. This amount will be credited today. I'll be able to take, and one more registration.
When I pass an order, if you don't comply with the order, you are not entitled.
My lord,
I will
let it have it on Thursday.
I will vacate
I'll
the
not-
order
my lord,
first.
we will come with the DD, my lord. 6th, let it have it, my lord. I'm not.
Why should we do it?
My lord, we'll be.
Why should the court be so accommodative?
My lord, because of the.
Not a public
my lord,
interest.
My lord, one submission, my lord, because the power was also not there, my lord. We were able to get the restored power.
You should have thought all this before making
My
so
lord,
many
those
submissions before
5
the court.
flats, we were not aware the power was not there, my lord. We were not aware, my lord. That is, and we were able to get the power connection. In fact, it is not, we are convinced that by.
No further arguments on Monday.
My lord, Thursday, my lord.
No, I'll post it or list it on Monday.
My lord,
By the
Thursday,
time,
my lord,
if
Monday
the DD is not placed before the
Monday
court,
only will be.
orders will be passed.
My lord, Thursday, my lord, your last chance, my lord. Thursday, my lord.
Did you ask for any clarification, modification,
No, it was
or extension of time?
My lord,
Did you ask for time, I asked? When are you supposed to pay the money?
my lord, 29th was supposed to be paid, my lord.
Did you ask for any extension of time from this court?
No, my lord, on that day, what happened, correction was done at the last moment, 4:45, my lord. That is, I could not make submission, my lord. 4:45 it was called, my lord, the end of the day, my lord.
It is not about submission. You have to file an application.
My lord,
Seeking extension of time.
My lord, Thursday, have this matter on Thursday, my lord.
I will not have it on Thursday. It will come on Monday. And I will pass orders.
No, my lord, we'll be able to pay, my lord. Monday is the registration, my lord. We'll get the money. I'm not seeking any, let have it on Thursday. I'll not argue, my lord, if I'm not with the deed.
Why should that indulgence be shown is the question.
My lord, I'm 100% will pay my money, my lord. So Monday is.
When the matter comes up, when the court shows indulgence, all statements are made before the court that I will do that, I will do this, and on that you take an interim order.
My lord, I've sent my
And
sanction
after
letter
that,
out
you
to
don't
my
even
learned
honor
friend.
the order of the court.
I've sent sanction letter to my learned.
You cannot say that. You cannot say all that, having not filed an application for
kindly-
extension of time.
Kindly have it on Thursday, my lord. Small request, one last request, my lord. Thursday, my lord.
I will adjourn it on Thursday on cost.
A small
Cost of 50,000.
Oh, my lord, please. We'll have it on. I will.
No, it has become a very routine practice to take the
extremely
court.
sorry, my lord.
It is not that he is like, where crores of rupees are involved.
I understand.
And why should the court, show indulgence to people like this?
I'm sorry, my lord. Let it have it on Thursday. Monday we have carried, and we'll get the money and we'll get the DD immediately, my lord.
Yes, what is?
My lords, I leave it to your lordships. On this point, I don't want to. My lords, only one thing is, on Thursday, whatever the payments they have to make, let them make, my lords. If it can be made on Wednesday, my lords, Thursday, I will come out with the remaining balance amount calculation, because again, on that, it will go on, please, my lords.
One
On Thursday, let the balance amount also be concluded, please, my lords.
No,
Otherwise, this will never end, please, my lords.
my lord,
List
what
this
will happen
matter on
to
Monday.
draw a DD.
List this matter on Thursday. By the date, the petitioner shall come up with the DD as directed by this court by order dated 24/6/2026, an amount of rupees, what is the?
10 crores.
An amount of rupees 10 crores. With regard to the remaining amount, learned counsel for the respondent shall come up with the calculation, and on that day, an order will be passed with regard to the payment of the remaining amount. If on the next date of hearing, that is on Thursday, if the petitioner fails to place a DD before this court, the writ petition will be dismissed with exemplary costs of rupees 10 lakhs.
Please.
This matter, the respondent number 8, actually he is alive. He is not alive. His representatives are arrayed as respondent number 2, 3, and 4. It's a
It is
small
a memo.
mistake from my side. I filed the memo on 29th, please, along with the 29th July, I filed the memo. along with the summons served on the parties and also the council. The thing is, respondent number 1 is, he is alive. I have mentioned that he is dead. I have filed the application for the amendment also before the court today.
No, code below it is shown as.
No, it's my mistake before this.
So no.
Court
before-
below it is properly is there. It's mistake from my side.
A memo is filed by the council for the petition stating that. That the respondent number 8, correct?
Mr. Shankare Gowda, yes.
Respondent number 8, Mr. Shankara Linge Gowda.
Only Shankare Gowda.
That's what you said so in your memo.
Yeah. That is, he is Shankar Linge Gowda is alive. He is arrayed as respondent number 3, serial number 3. He is alive.
For what you filed this memo?
Please. It is submitted that one Shankar Linge Gowda is alive. That he is arrayed as serial number 3 in the writ petition. He is alive. I mentioned he is dead. I filed a necessary
That is
application.
what I am saying. That is what I am recording.
Please.
He has to file application, my lord. The
I filed
constitution
it.
itself is showing that my lord person is.
Amendment petition, he has filed it since.
Today morning I filed.
Then along with that, I'll pass orders.
Interim order may be extended.
Interim order earlier granted is extended list this matter on 4th of August.
I appear for the petitioner, my lord.
You have served the hand summons?
Please, my lords, I have served and I have filed the acknowledgement.
How many are the respondents?
Respondents are unrepresented, my lords.
Served on respondents?
Served on council representing.
Respondents, correspondent council, that's 1 to 4.
Please, before the trial court, my lord.
It is, a memo is filed stating that the notice was served on the council appearing for the respondents as per the order passed by this court. Considering the same, notice to the respondents is held sufficient. The interim order earlier or granted earlier is extended. This matter in the month of September. Yes, next.
And for the respondent, petitioners, my lord.
Yes.
Memo of acknowledgement has been
copies
filed in the
served.
registry, my lord.
How many are the respondents? You have served all of them?
Yes, my lords.
A memo is filed stating that the same. A notice to so and so is held sufficient. Interim order earlier granted is extended. List this matter in the month of September.
And for the petitioner, I complied the order of this court, my lord. I filed the acknowledgement. I complied this honorable court. And summons served to the trial court.
Memo and summons served, acknowledgement not filed.
I filed it, my lord.
When was it?
30th, I filed it, served in 28th, my lord.
Whether there is a memo? But cause list shows that it is not
Yes, my
filed.
lord. It's,
Yes, list this matter on 13th of August.
interim order may be extended.
Look at it interim, if it interim order is there, extend. It's 12.
Obliged, my lord.
Your lordship.
12.
Sorry, 17.
Court officer is in a rush to complete the list.
That's, I'm appearing for the petitioner, my lords.
Hmm.
I have complied with the order, my lords. I have served upon the council appearing for DHR before the trial court. I have filed memo, my lords.
Same memo is filed stating that the notices are served, as per the order passed by this court same. And notice to them is held sufficient. Interim order earlier granted is extended same, just in the month of September. Yes, 13.
Applied.
And summons served, my lords, on 25th July. And acknowledgement filed on 29th July, my lords.
To all the respondents,
Please, my lords.
same order. September interim order extended.
Great.
I appear for the caveator respondent.
Papers were served?
Yes, I have received the copy of the writ
Yes.
petition.
Yes.
I appeal for petitioner, my lord.
What is this non-compliance of office objections? Non-compliance of office objections. This is 20653. Shows non-compliance of office objections.
14.
Copy of objections to IA to be furnished. Annexure to be stated at prayer 2 for the so and so.
Anyhow, the copy of the writ
Not about
petition,
your copy. It is.
copy
some
has
other-
been received.
Some other objections are there. Some other objections
Yes,
are there.
Some other objections,
Yes.
yes.
Well, in this case, what they have.
Ranked a dead person.
Huh?
We have ranked a dead person.
Hmm.
We will remove this within the course of the day. Meanwhile, we heard.
But the last time I hear this one, we will remove the objections, my lord.
You have to do the
The
objections.
extremely urgency is there, my lord. Tomorrow it is
If
posted.
it is extremely urgency, all the more reason that we should have complied with the objections.
Yes, my lord.
Trial court has adjourned this matter for not complying with the order passed by it. Two times.
When is it coming now?
Tomorrow, my lord. It is posted tomorrow, my lord.
That is 7/7/2026, writ petition is filed.
Yes, my lord.
Till now, you don't comply with the office objections. And every time the matter is urgent.
But last
Because it
occasion,
is coming
well,
up tomorrow.
last occasion, it was posted, my lord. Lordship had this matter and directed me to serve the copy.
That doesn't mean that you will not comply with
I'm
the
sorry,
office
my lord. I'm
objections.
sorry. I'm very much sorry, my lord.
One submission, my lord. The writ petition is filed to waive off the cost. Even though the trial court has reduced the cost, he has come to this court to waive off the entire cost.
Where is
Only that point is there.
Please come to the impugned order. Page number?
Annexure A. Order, my lord.
Yes.
Well, earlier, my lord, the IA 21 and 22 was allowed. Page 48, my lord, earlier order. On IS 21 and 22.
What are those IAs?
In this case, my lord, so for recalling the witness for further cross-examination, my lord, DW1. But they got IS 1 and 2, 21, 20 were allowed with the cost of 7,500 each, amounting to 15,000 each to the defendants, two defendants. Then when I filed IA number 23, my lord, to waive off this cost on the reason she is a poor widow, my lord, and a lady, my lord, she has no income. I requested the court, prayed the court.
Where is that order?
This order is Annexure A, my lord. Page 1. Annexure A.
Suit is of the year 2016.
16.
When was
Page
it-
17, my lord.
When was it, when was the evidence closed?
It was closed
In the month of June. my lord.
June.
In the month of June 25.
Application for reopening is filed on
21, 22 of applications were allowed on this application at 20th June 26.
He is not the advocate in the trial
But-
court.
but-
He may mislead the court.
No, man, I'm not.
See,
misleading.
I am the advocate in the trial court as well as here. Your lordship may kindly see, similar applications were rejected and two applications were allowed on costs of rupees 4,000. He paid the cost on the next date of hearing and prayed for time. It was rejected. It was posted for arguments. It is at the stage of arguments. So he is filing applications after applications. How is it maintainable? The Supreme Court has held the applications, continuous successive applications on the same provision of law, at the same stage, it is an abuse of process of law. I have produced the citation before the trial court.
What is the suit for?
Pardon me?
What is the
A suit for declaration and
For
injunction.
declaration and injunction.
And one more submission, my lord.
What is the court fees paid?
Huh?
What is the court fees paid?
Court fee.
Court fee paid is okay. There is no objection on that.
I'm saying, what is the amount?
Amount I have to see.
Where is the plaint?
Plaint annexure B,
Page number?
page number 18.
So your client, according to you, she cannot pay the cost, but you want it's a conditional order. If you cannot pay, let order go.
Only thing, she's a poor lady, that's why I am seeking, otherwise I would not have done that.
She is a money
She's
lender.
widow,
Plaintiff is a money lender.
Widow, she is a
From
widow.
the plaint itself, it is shown, she has lent 1 crore to the LR of the first defendant. That is their claim.
It is like
Where did she got the money?
either you withdraw this writ
And
petition.
violating the order passed by the trial court, her husband, herself, they have mortgaged the property, violating the order, mortgaged the property and have received 35 lakhs. Now she has got that, she is a money lender by profession.
No, it is not so.
Yes.
In the plaint,
I will establish it.
No, in the plaint, I have stated them, Lord.
Yes. Where did she got the money?
Please,
Arguments
arguments can't go on
ನೀವು
like
ಏನ್
this.
ಹೇಳ್ತೀರಾ ಸ್ವಾಮಿ?
Arguments can't go on like this.
Yes.
First of all, one has to complete,
Yes.
then I'll ask, the other can respond.
ಆಗ್ಬೋದು.
Yes.
In the plaint, I have stated, my lord, I have sold my jewelry and obtained loan from other relatives and paid rupees 1,05,000 to the son of the first defendant, my lord. My lord, for a business. When he failed to repay it, my lord, he is my first defendant, who is the mother of that defendant. She came forward. There was a compromise in a mosque, and she offered her property as a gift to me, my lord. That property, later on, my lord, that property I gifted to my husband. But then they filed a suit. We filed a suit for declaration, my lord. It was decreed. Therefore, they filed, my lord, so a miscellaneous petition to recall that order because it was an ex parte order. That after recalling, my lord, these proceedings are going on.
He is misleading.
I am not a money lender. Let him show it, but I am prove it that I am a money lender.
Yes.
He is
It is not so, my lord.
He is misleading the court.
He has to complete.
Yes, let him complete. Let him complete. I
Yes.
don't want to intervene.
I am not a money lender, my lord. After disposing of my jewelry, I am paragraph 8 of my plaint, I have clearly stated how I got that amount, how I paid it to the.
No, you have gifted it.
Well, thereafter,
You have gifted it to your husband.
Permanent
You have gifted the property to your husband.
husband.
How are you concerned with that? Your husband will take care of it.
No, he is no, my lord.
Huh?
On that point, I will.
No. I'm sorry. It is not gifted. She is she is the plaintiff. I'm sorry, my lord.
We'll see some other day.
Allala,
this is
only
matter.
only point is whether the costs imposed by the trial court is justified or not.
Yes,
It is justified according to me,
This is matter.
because the trial court itself on IA number 23, she has reduced the costs. The trial court has reduced the costs.
In the month of September.
Tell them, let there be a stay, my lord.
No.
Tomorrow it is posted, my
Let
lord.
it be, let it be.
It is the conditional order is stayed, but.
And I'll dismiss it.
Let it be disposed of.
Yes.
Let it be disposed of. No, he has not made out grounds for the main case itself. Where is the question of interim order?
The trial court has reduced
He is
only
misleading the court. No doubt, the case is posted for tomorrow. The question of interim order doesn't arise. Let him file a memo and be ready for the arguments on the next date before your lordship.
You are making the court to pass an order in his favor. That is the argument you are advancing.
No,
Please wait.
No, madam.
Please wait.
No.
I understood your arguments.
No, no,
Why
no,
you are
no.
repeatedly, why are you in such a loud voice? You're shouting literally.
My voice is like that.
Not necessarily,
My
no,
voice
I
is-
understood, I understood. I
My
understood
voice
the-
is like
I
that.
understood
Even
the
I am not,
submissions.
I am not
I
using,
understood the submissions,
I
Mr.
am not
Counsel.
using this microphone also. My voice is like that. It can't be helped.
Yes,
Right.
yes. Yes, what do you say?
Stay may kindly be granted, and posted for final hearing but next week any date, madam.
I'll pass orders. Yes, next.
Date, madam?
Dismissed. Order will follow.
Appear for petition.
Yes,
Yan summons has been duly served for trial court.
third. Same, as per the order passed by the court, so and so. Notice to the so and so held sufficient. Look at it, if interim order is there, extend. Yes, 17.
Interim order mechanism.
16, only one respondent, I served it on 25th.
Hmm?
I served it on 25th, only one respondent. And acknowledgement is produced on 27th.
Only one respondent.
Only one respondent.
Two respondents are there.
Only one respondent. Serial number 16.
Serial number
16.
16. Wait service of notice issued to respondent. Same, as per the order passed by this court. Interim order earlier granted, extended, September.
For the petitioner, your lordship, the hand summons were only ready on 28th evening, your lordship, and the suit is Chikmagalur. We already made arrangements, but hand summons are yet to be served, your lordship. I pray that be permitted to file a memo in the same regard, your lordship. The directions be given that we will serve this week, your lordship. Because hand summons weren't ready until 28th evening, your lordship.
On 17/7. 17/7, 2026, hand summons are ready on 28th.
Yes, your lordship.
Why?
28th evening only, you can,
20th or 8th?
28th, your lordship, 2/8.
No, not. Why will 10 days time will take for getting audit sheet signed? Find out from the registry why they are giving why are they taking that much time? This is matter on Monday. Yes,
Lordship, kindly extend the interim order, your lordship.
interim order is extended till Monday.
It is posted along with the submission of the
Just
learned.
along with, in that matter, the registry, it is a submission of the council that the hand summons are ready on 28th. Order is passed on 17th. Why they have taken that much time to give the hand summons? The explanation is called for the concern. Yes.
Appeal for petition, my lord. It is posted along with the submission of the learned honorable trial.
No, report received from the senior civil judge and JMFC. What is this report? Where is it? They say that another 8 to 10 months are required. The the petition is filing the following prayer. Considering the fact that this is a preliminary decrees of the year 2009. This court has called for a report from the concerned judge how much time is required to dispose of the matter. A report is placed before the court. stating that considering that several properties are involved and there's a huge pendency on the file of the said court, the learned judge has requested 8 to 10 months' time for disposal of the petition, considering the said letter. The writ petition, this court is passing the following order. The writ petition is disposed of, requesting the concerned court to dispose of the pending so-and-so within a period of 10 days from the date of receipt of the copy of, 10 months from the date of receipt of the copy of this sort. Accordingly disposed.
This matter, I'm appearing for the respondent number 1, my lord. Respondent number 2 has passed away on 9/3/2021 itself. The present petitioners who are the plaintiffs before the trial court, they have amended the plaint and the LRs are brought on record. In the instant petition, my lord, respondent number 2 is arrayed as party. And writ petition is
To
filed
carry the
against the dead
necessary
person.
amendment to the cause title then,
Please.
before this court also. You have given her?
No, my lord, they have not given that. Respondent number 2 is shown as, and the notice is awaited in respect of respondent number 2.
So whoever are the legal representatives before the court, you implead them.
Please, my lord.
Interim order is there.
Interim order is there. The only difficulty, 3/8 matters listed for arguments. Let them not precipitate that day, my lord, because my application was allowed for appointment of court commissioner since it is a case for recovery of money based on promissory notes, my lord.
No, there is an interim order.
If they proceed for argument.
Now, how
then-
will they proceed when there is an interim order?
Interim order only of the order, my lord, impugned order, not.
Operation of the order dated.
So let them not precipitate at least before the trial court. Because if this order, my lord, if my lords were to hear the matter, and in case if the writ petition.
Then appointment of advocate commissioner, you're saying.
Appointment of scientific expert, handwriting expert.
What is the stage of the suit now?
For final arguments, my lord.
Lord, it has been.
They are
11
the
years, my
plaintiffs,
lord.
let them not precipitate since the writ is
It has
pending.
been 11
This
years,
is
my lord.
matter on 18th of August. The petitioner shall not precipitate the matter. And by the next date of hearing, they shall implead the LRs of deceased.
Respondent number 2.
Respondent number 2 who are already impleaded before the trial court.
My lord,
Great.
interim order may be extended. Interim order may be.
Interim order earlier granted is extended. Yes, next.
Petitioner, Your Lordship. Regard to the final application before the Honorable Court.
Maintainability.
Maintainability regard to IA I have filed, Lordship. As an objector, I appeared before the Honorable Court. That came to be dismissed. On the account that it is a transaction between the objector, JDR
This is why
number
the
2.
court said in view of registry raised objection in view of section 96.
I'll just finish. I'll be within 1 week. I'll just please.
Huh?
Objection, I'll be.
Not those objection, when an order 21 rule 97 application is dismissed,
Yes,
again
Your
is that a first appeal lies.
It is, I have filed one more case, Your Lordship, against the JDR too. That is pending for injunction. That is pending. It is not over. That is still pending. In this case, if any order will pass, I'll come on the road. I am the bona fide purchaser. That is the reason, Lordship. I was not aware of the proceedings.
Office objection with regard to maintainability is
Please.
sustained. Petitioner shall avail the appropriate remedy within a period of 1 to 2 weeks from the date of receipt of the copy of the order. The registry shall return all the documents by keeping the copies. Yes, 21. Non-compliance of office objections, counsel submission. No representation on behalf of the petitioner. This is matter in the month of September.
But initially, office had raised the objection that for two orders, orders on two IAs.
What are those IAs?
IA number 9 and 10.
What are
9,
those?
9 is for amendment application. 10 is for scientific investigation for handwriting expert. 9 we are not pressing. It's a money suit, recovery of money. Is a schedule. The money,
Have you said so?
we have replaced that prayer page in the writ petition.
So what are the objections now?
Now that objections to IA number 9 is not forthcoming. That is the office objection.
Grant an interim order to say so and so. Page 28, not forthcoming, same to be clarified.
That is objections to IA number 9. Since we are not pressing amendment application, IA number 9, that office objection may be overruled I'm confining my prayer only to IA number 10, which is.
When council submits that they are not questioning I number 9
Yes.
and they are confining the writ petition to only I number 10.
10.
And the office objection with regard to page 28 annexure E is in reference to IA number 9.
9, yes.
And hence the office objections may be overruled considering the fact that the petition is not pressing on IA number 9. Office objection is overruled. Yes.
Suit for money filed by the plaintiff on the basis of a mortgage deed executed by defendant number 1. During cross-examination of defendant number 1 conducted on 14th January 2026, she denies her signatures. The cross-examination is concluded on that day, 14th January 2026. The matter is posted for arguments on 20th January 2026. On that day, I filed 2 applications, amendment application and the Order 26 Rule 10A application for referring the disputed signature for handwriting expert comparison. Both the applications are dismissed on the ground that once the matter is posted for arguments, it cannot be reopened.
Yes. Let's see that order. Page number.
Page 10, my lord.
Page number.
Page 10 onwards. Para 50 is the relevant page. Page 17.
This deals with the Order 6 Rule 17.
This is initially.
No, you're sticking your prayer to Order 6 Rule 17.
No, my lord, I'm not pressing on
Then
that.
where is that other one?
Para 15.
15, coming to the merits of, yes.
Both it is coming to the merits of IA number 9 and 10 is concerned. The proposed application as well as appointment court commissioner filed after the case is posted for arguments and the plaintiff in the affidavit annexed
Put
to
for recovery of money based on a promissory note.
Mortgage deed. Annexed to IA number not made out any grounds in spite of due diligence. The proposed amendment totally changes the schedule of the property. Further, this is important. Further, IA number 10 is concerned, as aforesaid, since the matter is
Please
posted
come,
for argument.
counsel, the petitioner submits that the suit is for recovery of money, and in that an application is filed seeking IA number 10 is filed to send the disputed document for expert opinion. That came to be dismissed only on the ground that the matter is posted for argument. Considering the submission, there shall be stay of all further proceedings. For issuing to the order dated so and so, notice to the respondents, hand summons. Memo shall be filed by 10th of August or else a stay granted by the court stands vacated. Is 20.
Notice has been taken, my lords, but oversight, my lords, hand summons was not taken.
Why not taken?
After 2 days, my lords,
I think you can, now you have an interim order.
Please, my lords.
I said,
Please, my lords.
if the memo is not filed, hand summons, by serving the hand summons, the stay will be vacated.
Petition was sent to the my lords trial court advocate, but my lords, hand summons from the court not taken, my lords.
That is the order.
Please, my lords.
When you can look at this, when you can understand and take that stay order, you can also understand what are the other.
Please, my lords.
I know this is how, what is happening in the CPC.
My lords.
Interim order taken for years, no service of summons.
Immediately after 2 days, my lords, he went to this branch, my lord.
A memo, this court has already directed the petitions of the hand summons on the counsel appearing for the respondent shall file a memo. In spite of that, the petition has not taken hand summons. List this matter on 10th of August. By that time, if the hand summons are not served, without further reference to the court, the stay granted by this court shall stand vacated.
Please.
Interim order earlier granted is extended till then.
I am for the respondent in this matter. Petition as well as the annexer, they are not supplied at all. Except the. I'll complain.
The petition shall comply with the office objections and also serve the complete set of the papers on the counsel appearing for the respondents. List this matter on 13th of August.
Much.
What is this memo? Some memo is. You file the caveat. Papers are served.
Third. See, they wanted to, my lord, third round for leading the further evidence of the plaintiff. After completion, matter went it posted for argument, then recall the DW1 side. After completion of DW side, my lord, by filing the 3 applications in a different stage, a similar application. I said I no objection. Then now, my lord, third round to reopen and leading further evidence of PW. Now
No
the present
representation on behalf of the petitioner. Learned counsel appearing for the caveator is present. List this matter in the month of September.
Much.
My lord, I'm challenging the disposal order in regards of IA number 10, which is at annexure.
Where is the impugned order?
My lord,
Where is it?
at page number 56. The order is at page number 12. My lord, at para 11 and 16, my lord, it is very important to look at para number 11, page 8. May I read?
Yes.
Page number 8, para 11. However, in the present case, plaintiffs have sought production of large number of documents without demonstrating the relevancy and necessity of each document with reference to the matters in issue. My lord, again, at para number 16, my lord, I'll read out the whole para. In the case on hand, there is no clear admission of by defendant number 1 and 2 that all the documents mentioned in the applications are in their possession or power. Further, a substantial number of documents sought are public documents which are capable of being secured by the plaintiffs from the concerned authorities in accordance with the law. The applications also do not explain the relevancy or necessity of each individual document. But my lord, at page number 15, 63, my lord, I have explained the relevancy of each document, all the 7 documents which are very crucial and necessary for a fair disposal of this
No, please
matter.
come to page 13. Why should come to page 13? Look at those documents and why only the plaintiff should produce all that? Why can't it? They're all, look at it. Page 13.
My lord.
Page 13. What is the first document?
First document, my lord, true copy of all 308 deed of declaration filed in the office of competent authority. My lord, according to him, he has submitted 308 deed of declaration. There should be actually 1 deed of declaration which I have sought through RTI and already submitted at the time of filing the petition itself.
No, it is not required.
My lord,
if you have already submitted, it is not
my
required.
lord, he submits that the defendant says that in the written statement, my lord.
You want the plaintiff to produce 308 deed of apartments filed in the office of the competent authority.
My lord, there is actually 1 deed of declaration.
So that is what you asked, B.
No, but the defendant has made a false statement. My lord, kindly come to the para number 31B of the
Let them come, we will understand what are the documents and what is the relevance.
My lord, this is very simple matter. There are at least, I require, if not all the documents, I only require.
Then why you unnecessarily file application with all this? If you have filed for relevant documents, court would have allowed it.
My lord, let me explain. Deed of declaration, Form A, Form B, and deed of apartment. These are the very necessary.
Take out hand summons on them. Once they come, I'll pass orders. Whatever after hearing them.
My lord, there is a IA for stay also.
No, there will be a IA in every matter, but we will not just like that grant. What is the urgency to grant stay?
My lord, these documents are very
Correct, we will-
necessary and
I will take it up next week. By the time you take, the court will not hear your matter on a day-to-day
my lord,
basis.
this will only take 3 minutes, my lord, because,
But
my lord, moreover,
This can be finally disposed. No stay of the proceedings required in this case. This is matter on 18th of August. By the time by 17th of August.
the next date of hearing is on 13th, my lord.
On 13th.
And it is for evidence.
This is matter on 12th of August.
My lord,
By the time the petitioners saw the copy of.
Allah, the evidence, it is for evidence. I have to submit the evidence. Moreover, I have filed an application for interrogatories.
I'm saying I'll take it up before the matter sets up.
At least, my lord, on 6th
I
or
will not grant.
the first week of.
This is a matter on 10th of August. The petitioner is permitted to take out hand summons.
3 and 4
File a
I'll take
memo to
notice.
that effect by 7th of August. Then list the matter on 10th.
Lord, respondent
That
3 and
this
4
is
I'll
a
take
very
notice.
simple matter.
3 and 4 I'll take notice, madam.
3 and 4, AGA takes notice.
Please, Your Lordship. Before respond. Lord, I represent the petitioner, my lord. Defendant's landlord's writ petition challenging the order, my lord, passed on IA number 2, granting ex parte police protection order.
Come to the top.
Please, my lord, annexure D is the impugned order. Now, what had happened is, my lord, the suit for permanent injunction was filed by the tenant against the landlord. My lord, ex parte injunction was granted on 7/7/2026. Kindly go to, my lord, ink page 50, my lord. Ink page 50. Ink page 50, man.
No, 50 I've seen. It is about notice.
Matter was 7/7, my lord. It was granted on, my lord, 7/7/2026, my lord. Relevant portion, page 58, man.
Yes.
Ad interim ex parte temporary injunction is granted restraining the defendant, his successors, legal representatives, administrators, claiming through him henchmen from illegally interfering into peaceful possession and enjoyment of the right to conduct liquor shop business of plaintiff over suit schedule premises till next date of hearing. Issue ad interim ex parte temporary
You are
injunction.
saying about police
It was
protection.
posted on 21/7.
No, you said police protection. Where is the
Next
police?
order, man. It was posted on 21/7. Next date. We were not notified. Well, sorry, we have not yet received the, my lord, notice. Case is advanced on 13/7. And IA number 2 is filed for police protection, page 60. 59, my lord, is the application order. 59, it starts to advance the case.
On the application. OS. 1416. Page. Next.
Are you obstructing or not?
Page.
It is, I have also filed a suit for, my lord, eviction against the respondent tenant, and page 64 is the injunction order granted in my suit.
May I just explain?
You are a party to the suit.
Yes, ma'am. May I just
Then, my lord, one more submission. One more
You are a
submission.
party to his suit.
Yes, my lord.
And that is stated in your plaint here.
Yes, ma'am.
One more suit was filed before the. But just a minute.
After he completes
Before the suit, my lord, before the civil court for restraining, my lord, the defendant. Sorry, praying for protection of ingress and outgress. Injunction was refused. Identical prayer, my lord, injunction was refused, my lord. I have produced annexure G. I have produced annexure G.
What was your suit, you said?
my suit is for eviction. Earlier suit is, my lord, for injunction. One more suit was filed, earlier suit was filed for injunction.
You filed the injunction, you got injunction.
No, I have not filed. He himself has filed earlier suit before the civil court. This suit is filed before commercial court.
That is, injunction is granted.
Injunction was refused. MA was filed. That was injunction, whatever refusal order was confirmed. Now that suit he has withdrawn. Sorry, it is pending. Regarding the rejection of the injunction in the earlier suit, has it nowhere it is stated in the, my lord, present suit. So only our limited grievance is, my lord, ex parte temporary injunction was granted. If they want police protection, but they should have served the copy on us and passed that is the law, my lord.
They say that is already complied with. The court observes that somewhere it is observed.
But we have not been notified, my lord. If there is any violation of the injunction order, but they should have served us. They should have filed appropriate application for police protection. Date was fixed on 21/7. Kindly see, my lord. Advancement was made on 13/7, and nowhere in the plaint regarding rejection of the earlier application for injunction has been stated. So therefore,
yes.
May I just? It's a landlord and tenant dispute, madam. Admitted facts are that they are the landlords, we are the tenants. The further admitted facts are that the period of tenancy is got over, despite which he is receiving the rentals. And there is a notice issued by him on 106 TPI.
You are the tenant.
I am the tenant. I am the tenant. I filed a suit because at an earlier point in time, which my learned friend said, because they were trying to put up some construction in front of my shop. I have taken a C9 license conducting a liquor shop, carrying out business of liquor shop. So then I approached the court, not requesting the court to prevent him from not to put up any construction in front of the rental premises. Only the limited prayer was for ingress and egress. That's the word that I have used in page 68. That's the prayer that I sought. For ingress and egress I sought. Then he came with a defense saying that he is not doing it. He is not obstructing me. The trial court refused injunction. I filed a MA. Refused. My MA was dismissed. In the meantime, what he did was he prevented me from carrying out the daily activities. The keyhole of the shutter, he sealed it. So I went to the police. They didn't do anything. I came to the court. I got an injunction. On the same day, that is on 6/7, I filed the suit. He also filed a suit on the same day. I filed it in the commercial court. He filed it in the rural court. He filed a suit against me saying that I should for eviction quit and for delivery of vacant possession. And I filed a suit for injunction not to evict me without due process of law. I got an injunction. Then on the next day, that is on 6/7 I filed, 7th I got. Kindly see in ink page 58, I have complied. He has received the notice on 8th. I have complied. Then what he did was he covered that keyhole. Then I went to the police. Then I again came to the court. I filed an application by virtue of my Lord's judgment saying that I can take the police help. My Lord's judgment is there exactly on the same point. I produced before the trial court. Trial court gave me an order that is in page 59 where it says that I can take the police help. With the police help, I opened the shutter. I'm carrying out the activity. This is the fact situation. Till today, he has not challenged the 39(1 and 2) order. He is directly now challenging before my lords this police protection order. The injunction order is yet to be challenged. There is no 39(4) filed. They just filed an objection. There is nothing else that has happened. Therefore, I am well justified in going to the police and also taking possession back because my tenancy is continuing on a monthly basis. It is not in dispute that he is not taking the rentals. He is receiving the rentals regardless, and he has filed a suit saying that I'm in possession. I should evict and deliver vacant possession to him. So my possession is impliedly accepted.
No, but the case is you are not in possession.
I'm not. I'm in possession. He has filed a suit, my lord.
You are saying that he has closed it.
He closed it illegally. He closed it. He did the welding of the keyhole.
So as on the day when you're filing the suit,
I was in possession. I was prevented. I was in possession. My lakhs of rupees stocks are inside. He illegally. Then I went to the police. They did not do anything. So I went to the. I came to the court.
We can understand that when you seek for an ad interim injunction, you should be in possession of.
I
the
am in
property.
possession, my lord. Only the key,
Physical possession of the
I am in
property.
physical possession. My cash box, everything is inside. Only keyhole is the only this welded. No, so that I should not open the lock and carry out the business activity.
Where is that injunction order granted by the court?
By the,
Interim injunction, where is it?
the one my learned friend read, in
Let's see
page
that.
58,
58 is.
what my learned friend read is the order that I secured.
58.
Yes, my lord. 58.
No, what is the discussion on that?
Discussion. May I request 56 para 12.
You have, the plaint is there before the court?
Yes, my lord.
Where is that?
My plaint is ink page. Starts from 17. And I have also made a mention of the earlier suit in para 7, line 10, ink page 19.
No, with regard to your possession, which para deals with it? Where did you say so?
Para 10.
Hmm.
It is submitted that the plaintiff normally continuing his business over the scheduled premises without prejudice to the interest of the defendant. Defendant all of a sudden on 4/7 again started to interfere into peaceful possession, business of the plaintiff over the scheduled premises by sending his henchmen to the scheduled premises on the guise of defendant about 10 a.m. His fellow henchmen spotted the scheduled premises, started to abuse the plaintiff and his workers by doing their business, by threatening to their life, warned to seize the scheduled premises, created mess over the same. Thereafter, immediately plaintiff called the jurisdictional police. When the plaintiff informed about the illegal interference, mess created by the henchmen of the defendant, their life and the scheduled premises was cautioning to vacate the scheduled premises. And his suit, my lord, one more important aspect is, he has filed this suit, my lords will get that at.
Where did you say about that he has closed that shutter?
I'll. On para 12, ink page 21.
Hmm.
Amidst the plaintiff on the very same day on 4/7 has unloaded liquor consignment to the scheduled premises, what so and so and so, from KSBCL, Whitefield, Sunday is the weekend till lucratively, the copy of the invoice so and so, after 2 lines. On the contrary, even though the plaintiff lodged criminal complaint, jurisdictional police have registered FIR against the defendant. Defendant comes along with the henchman early morning about 8 a.m. on 5/7/26, accompanying with welding machine, welded the shutter, keyholes of the scheduled premises as the plaintiff did not open the scheduled premises, run the business. Made that statement before the court. The illegal interference, the defendant is illegal.
What is the injunction that you saw?
Not to interfere. Application. They have not filed my application. They have, because they have challenged only the police protection order. They have not filed my application.
So according to you, as on that day, when you have filed the suit, it is closed.
It is closed, only the keyhole is welded.
Because
But I am in possession.
No, unless and until you open it, you can't enter into the premises.
I could forcefully do it, but I took the help of because the police did not help me. He filed on the same day asking me to evict, saying that I'm in possession. I should give him possession on the very same day. He himself admits. That order is also produced. This thing is also produced, original.
So
suit.
according to you, your goods are inside. Inside, premises is locked. According to you, it is.
I have locked, my lord. Premises I have locked in the night. What he did was he came in the morning. The keyhole is only welded so that I can't put the key to the hole to open the shutter. So I went to the police. They did not help me. Came to the court and got this. So I am in possession. And the same day he files the suit saying that I am in possession, I should be evicted and for deliver vacant physical possession because he is a landlord. I'm a tenant. And the rental agreement period is over. So he admits my possession. On the very same day he produces. May I read, madam? Page number 61, annexure E. Para 2, clause A in order sheet. Direct the defendant. Kindly, my lord, may kindly see the date of filing, 7/7. date of registration. Date of filing is 6/7. I have also filed the suit on 6/7. Direct the defendant to quit and vacate and hand over, deliver vacant possession of the suit schedule property, normal and good condition to the plaintiff. And his plaint, my lord, in ink page 65, annexure F. ಇದು ನಮ್ದು Tejas inventory. He has not produced the plaint is not produced. OS 141826, his case, plaint they have not produced. Only the order sheet they have produced. Kindly come to ink page 47, annexure D and annexure E may kindly be seen together. Annexure D is the suit that I filed. Annexure E is the suit that they have filed. Both are filed on the same day. May I just pass on my lord's judgment in this? Madam, may I just pass on my lord's judgment?
But that is after my lord contest.
No, that is altogether a different.
No,
facts and
but the
circumstances.
principles of law, which my lords have deduced the principles and.
For this case, somehow I have how a bare suit for injunction is maintainable in this.
It's a recurring cause of action. The earlier suit that I filed because he was trying to obstruct me from entering the premises.
So as on that, you're not at all in possession of the.
I am in possession, my lord. Kindly.
That is the question now.
It's a question which my lord had to travel beyond what I have stated because somebody comes, my landlord, he only welds the keyhole. The entire business premises is.
Order, court has granted an order putting you
back,
putting you in possession.
Putting in possession
That
because
is the
of
intention.
only to open the shutter. Not that I was not in possession, only to open the shutter and carry on the
I
business.
am looking at the order of the
Order,
court.
my
How
lord,
it dealt with it.
It's there, my lord. I'll read out. May I read page number 51, man? Not 51. 59 is the order in challenge, madam.
We can read from para 13.
No, 59 is the order that is impugned. This is the one that is in challenge before my lords.
I am looking at while granting injunction.
Earlier.
What the court has.
I will read.
Court has looked into.
Ink page 53.
No, it starts at 53. Come to para 11. 11, it is at page.
Interfere in the peaceful possession enjoyment right of the plaintiff to conduct business in the suit schedule property by the defendant would cause untold hardship and inconvenience to the plaintiff. Hence, balance of convenience lies in favor of the plaintiff. Document produced by the plaintiff shows that irreparable loss and inconvenience would cause to the plaintiff in the event defendant succeeded in interfering into the peaceful possession enjoyment of the right of the plaintiff to conduct business in the suit schedule property, as the same would cause loss to the plaintiff in his business. Document produced in support of the averments made in the plaint and affidavit filed in support of IA clearly demonstrate that the plaintiff has got right and there is an apprehension by the defendant that it may be infringed. Not preventing the defendant would lead to multiplicity of proceedings and it would cause untold hardship, inconvenience to the plaintiff which cannot be compensated in terms of money. No imminent inconvenience, hardship would cause to the defendant in the event a limited injunctive order is granted not to interfere with the peaceful possession enjoyment right of the plaintiff to conduct business in the suit schedule property. Further, in the event an appropriate order is not passed before.
By that time, there was no peaceful possession to you.
No, my lord, my lords are questioning me on this welding and closing the keyhole. Till the last evening, I was in possession. It is not that he never got possession. He never got, because he prevented me. This is a clear case where injunction should be granted. I had closed the door, I had put the lock and I had gone home. When I come in the morning, he has welded the premises. That doesn't amount that I am not in possession and he is in possession. It clearly amounts to an interference. Because and on the same day, he goes to the court and says that I am in possession, I should hand over possession. There cannot be a better admission than this, my lord.
Where is that?
My lord will get that in ink page 61 and annexure E. Kindly see that with ink page 47. Kindly see these two.
60?
61.
Let's see.
Juxtaposed with 47, my lord. My grateful support.
First, let's see 60, this order.
60 is this order.
Oh,
My submission to my lord is to see page 61. 61.
Yes, I'm looking at 6-1.
Great, great. Kindly see the fourth line. Date of filing, fourth line is 6/7/2026.
Hmm.
And the first line is Ganesh Narayan Reddy. He is the landlord and I am Tejas. I am the tenant. Kindly see the wherefore the plaintiff A direct the defendant to quit and vacate and hand over, deliver vacant possession of the suitable property in a normal and good condition to the plaintiff. He admits my possession here.
This is dated
This is 6/7.
6/7/2026.
Yes, my lord.
When was the injunction granted to you?
7/7. Kindly now see ink page 47. Because this is one that I went to court. This is the one that he went to court, to the rural court. I went to commercial court. Kindly see Tejas, tenant. On the right hand side is the landlord, Narayan Reddy. And line 3, date of filing is 6/7. So both of us has filed on the same day.
Yes. Yes, Mr. Senior Counsel.
My lord, it is, my lord, it's a suit filed for eviction, my lord, on the, on 6th. As on 7th, my lord, he was not in, even according to him, he has closed the door and we have put the hole. So, my lord, he was not in possession. It's a disputed question to be determined. On 7/7 injunction was granted. It was posted to, it has been posted to 21/7. But he files an advancement application on 13/7. But advancement was allowed on the same day. Police protection is granted. But now injunction, whether he was in possession, that has to be determined. Let the trial.
In the facts and circumstances, there is no determination required. Why did you ask for eviction? So what, if you say that as on that day he is in position and after granting injunction in his favor, if he is not in position means
Our objection.
you have forcibly dispossessed him. That only the inference can be drawn.
So far as my lord, possession is concerned, my lord, he is in possession. He may be in possession because he is a tenant, but he is not carrying on business.
That is a different aspect.
And now injunction is granted.
No, without a due process of law, you can't evict him.
Well, we will not. No, as on today, my lord, I am told, my lord, there is no carrying out of business. And my lord, the police protection order, my lord, this honorable court has held that, my lord, only after injunction order is, my lord, confirmed, then, my lord, an application lies. Now we have filed written statement, we have filed our.
Because that if you are referring to a division bench judgment of this court, there are contra judgments of the Honorable Apex Court in this regard.
My lord, there is one more judgment of this honorable court.
That's what I'm saying. There are judgments of the Supreme Court. Now ultimately, the purpose is to see that the orders of the court are honored and implemented.
Kindly see, my lord, matter is posted to 21.
No, we'll make it very simple. No. That's what I'm saying. We'll make it very simple. Your admitted facts, you're the landlord, he is the tenant. He seeks for injunction, you seek for eviction. Seeking eviction itself presupposes that he is in possession of the property. Let the court grant whatever order in your favor, but you have accepted his possession. When was that possession? When did you dispossess him in the way known to the law, which is recognized by the law?
Carrying of business. Here, my lord, question is carrying
He is in possession of the property. Whatever he does with that premises.
That has to be, my lord, whether he is entitled for injunction, because in me of, I have produced the annexure G, may kindly be seen, in page 71. He files a suit, kindly see, madam. Annexure G in page 71.
Yes.
He files OS number 318 of 2025.
Yes.
Praying for permanent injunction. In that he has sought for injunction. That has been rejected. That has been confirmed in miscellaneous appeal. Those facts have not been stated in the present suit. This suit has been filed in the before the commercial court. But obtains an ex parte injunction on 7/7. Matter is posted to 21/7. We have.
No, ultimately, what is the order of the court?
That has to be not that.
No, what is the order of the court? Order of the court is not to interfere with his peaceful possession.
If injunction is confirmed, he is entitled for police protection.
I'll appreciate. And what are the judgments you're relying on?
May I just pass on a compendium so that the photographs and the C9 license that I have taken, which is currently running.
Is it before the court?
Yes, madam. All the trial court.
Yes, take that. What are the judgments you're relying on?
Lord, may I pass on?
Take that. Yes.
But only my limited prayer is, if he is in possession, if he is carrying on business, let him carry on with the business. That is a disputed question. We have filed written statement, we have denied. Only limited prayer is police protection order, my lord. Let the honorable court hear us and pass the correct. That is the limited prayer. If he has.
What for the police protection is granted?
But that is a matter to be decided.
I'm asking you what for it is granted.
Other court could have granted an order of police protection ex parte.
Unfortunately, what will happen is, I'll tell you one more thing. If this is the argument on behalf of a petitioner who filed a suit for eviction, then all this will all reflect, the whole conduct will reflect on the case of the landlord. Because having come to the court seeking eviction of a tenant, and if this is the manner in which he is contending before the courts, then court has to presume that there is a illegal a high-handed interference.
Manner known to law, my lord, the court could have granted.
That is what.
Only on the any next date we will appear on Monday itself. Monday it is posted. On that day we will appear, but we will file our objections to the application. Then, my lord,
This is a altogether this case. It's a classic case, and it depends upon, it is completely stands on a different footing than any other case of injunction.
my lord,
In the light of the admitted facts, court is not, when there are admitted facts, they need not be
no
proven.
injunction order is not yet confirmed.
Not necessarily. Then what does it mean? Then it means, no, it means interim order, if it is not confirmed, then why should we pass, when that order has no sanctity, why the courts are passing interim orders?
But if now I have an opportunity to contest the case. Ex parte injunction, I have got an opportunity to contest the case.
I understand.
Now, my lord, it precloses all my avenues, my lord.
If you have not filed a suit for eviction, the submission what you are making,
May I make one
that would
submission?
hold the.
But may I make an alternate submission? We will file our objections both to the injunction application as well as police protection application. Till then, let this order be in operation. And let the learned trial judge decide, my lord, both their views. If he is in possession, if he is carrying on business, let him continue. But now, at this.
There no if.
He just now
There is
submitted
no
that I am in
if.
possession. He just now
Because
submitted.
your eviction suit latest shows
If he is in
that.
possession, there is no dispute. But whether he is carrying on business,
That is not the subject matter of the injunction suit. His case is, he is a tenant, you should not interfere. That's a simple case. So we are not concerned with business. That is all the more fortified by your admission in the suit for
that is a matter
eviction.
of my lord, determined, my lord.
Your admission, what is to be decided?
Carrying on business, I have denied. There are 10 years, I have filed my written statement denying, my lord, his carrying on.
His case is not, he didn't ask for anything. He asked for he is in possession of the property. Don't interfere with his possession. That should be the minimum order.
Without following due process of law, we will not dispossess him.
If you are not doing it, where is the question of police protection?
Regarding carrying on business, my lord, regarding injunction, my lord, we have grievance. Whether he has got valid license, whether it is all question to be after filing.
Let us see what did the court say by granting injunction. Please come back again. Let us look at it.
Some documents.
By granting police protection.
Restraining the defendant, claiming through him henchmen from illegally interfering in disputes. He has taken your shop, the premises, on rent for conducting business. If there is any violation of any, there is no license, he is doing any business contrary to the terms and conditions of the license or any other thing, your remedy is to go before the excise authorities and give a complaint against this person. That would be decided by them. As far as your relation and his relation is concerned with regard to,
Indirectly, even against excise department injunction is granted.
where is that?
Right to conduct liquor shop business, kind is it?
Against you, where is the excise department a party? Now, even if it is granted, it will not
It binds the excise department.
Why it will bind when he's not a party? What? No, no, Mr. Senior Counsel, please don't tell that kind of propositions.
The consequences of this injunction.
No consequences. Injunction will bind the parties who are parties to the suit, not to everyone. It is not it's not an order in REM.
Only thing is, no ex parte injunction order is granted. I have filed my written statement and objection. Let the learned trial, they hear us and till then this order may continue. Till then.
That is what will happen now.
No, no police protection is granted, and that is.
Tell the court what is going to happen to you if this order is granted. You have admitted his position. What the police will do?
Party injunction. Kindly see the procedure.
No. Let us not go into technicalities. What would be the implication of that order? We will see. Now, you have admitted his position. His case is that let the landlord not interfere with my possession. That is admitted facts. Now, even if police protection is granted, what is that you are going to lose? So, with this argument, what the court can infer is that you are high-handedly.
It is also granted in my favor, in my suit, not to change or alter the nature of the property.
What they are changing?
That is
I will also observe that as ordered in your case, they will not change or alter the nature.
I will not.
That they will follow the injunction.
It should not bind the excise department. This order.
It will not. It will not. That I will clarify. Why will it? When he is not a party, where is the question of even clarification not required? When the excise department is not a party for suit for injunction, where is the question of they binding by this? And any judge.
Any observations made in this petition will affect our case, my lord, before the.
That's why you should better withdraw this.
Inviting
Otherwise, I am intending to go write an order on these kind of exigencies and contingencies.
Then we are permitted to withdraw, my lord.
Yes, dismissed as withdrawn. Petitions are at liberty to all the contentions are left open to the parties.
Great.
I'll give those documents.
Respondent in this case. The suit for eviction, the respondent says he filed an application to vacate.
You will have an interim order from 2024. It's a suit for eviction.
Suit for eviction.
What is the order?
On 7 Rule 11, the application of the defendant 7 Rule 11 was rejected. On an appeal, the revision petition, they are before this court, they have obtained the stay. But another submission.
What is the
since 2
reason
years,
for the, no, why the court has granted stay? What are the reasons recorded?
no record.
Then counsel for the petitioner submits that the plaintiff does not disclose cause of action. Tenancy has not been terminated. Issue emergent notice to the respondents. Interim order 10/12/2024. Almost 2 years you are enjoying an interim order.
Last time also they had sought for an
Because
adjournment.
anyhow, you will again ask for time.
Just next Tuesday.
Order 7 Rule 11, we need not keep the matters pending.
Para 13 of the judgment, the trial court has clearly held that I have pleaded all the necessary ingredients requirements for an eviction suit.
This is matter as a first matter on, Anita, it should come as a first matter, not at 2:30. This should have a first matter on 5th of August. No further time will be granted. If the petitioner seeks for time, the writ petition will be dismissed. The CRP will be dismissed on that ground. Yes, 29?
Grateful.
Extreme urgency.
Extreme urgency should be argued now. Seeking adjournment, it will go as per the convenience of the court.
And I have to file objections to stay application. I also see.
Not required though.
Please.
No objections in a CRP.
Please.
It is not contemplated at all.
Please.
the Liz's matter on 12th of August. No, yes.
Appearing for the petitioner.
What is this recalling of the order?
My lord, the matter has been dismissed. It has not prosecuted.
When was it dismissed?
It was dismissed on
27/3/2019.
immediately I have filed an application.
So when is this order? 30th October 2025.
October 2025. Thereafter, I filed an application.
Revision petition itself is of the year 2019 and yet to be admitted. Order sheet discloses that the petitioner is not diligent in prosecuting the matter. Order under revision is a dismissal of the miscellaneous petition filed with the petitioner seeking restoration of the suit, which is a money decree.
My lord, the suit for recovery of money, the 22 years college student claims to paid 1
There
lakh
is no
rupees.
representation on behalf of the respondents. I number 1 of 26 is filed to condone the delay of 39 days in filing the recalling file seeking to recall the order dated 30th October 2025. Then council submits that immediately the application is filed and for the reasons stated, there's a delay of 39 days. Considering the reasons stated, the delay of 39 days is condoned and consequently order dated 30th October 2025 is recalled, considering the fact that the court has dismissed the case for non-prosecution on the ground that on that particular day, the petitioner has not appeared before the court. Accordingly, all the IAs are allowed and the CRP is restored to file. List this matter on 19th of August.
Interim order may be extended, my lord. My lord.
Once
Please, I do
it
agree, my
is
lord, because
restored, everything will restore. Once the CRP is restored to the original position, as on the day, whatever it is there, it will come.
because tomorrow the execution.
Order earlier granted is extended. Yes, next.
Much.
I'm ready, my lord. Appear for responding 3 to 6, my lord. I have filed application for vacating the interim order.
Lord, I am.
Just place
My lord, I am for respondent number 1, my lord. I am the financial institution on whose behest the petitioner became the owner of this particular property. Unfortunately, my lord, there is a vacation application that has been filed by the co-respondents. They have not served it on me. While this order is greatly impacting my role in this whole matter, there is an interim order that was passed on 19th of September, wherein there were certain remarks that were passed against me, and those remarks were squarely in relation to certain matters that were pending before the trial court.
Where is that order?
The last order, my lord, of 19th September 2025, my lord.
19?
19/9/2025.
In
19/9/2000?
WP 28721.
Huh?
28721.
Lord,
The
I'm-
interim order was granted on 19/9/2025.
This is point 1, my lord. The first item, my lord.
The first
31.1, my lord. Item number 31.1.
No, what about in 31, what happened?
My lord, both are connected suits.
Both are connected,
I have
my lord.
purchased the property in an auction conducted by.
Petitioner is, you are referring to an order dated 19/9/2025.
Please, my lord. Yes, my lord.
This auction purchaser.
And if I may, my lord, if I can take you to the prayer that has been sought, my lord.
I need it for WP 28721.
I'm getting the application.
No, because this is the whole problem. What is wrong with this order?
My lord, the
You
difficult.
don't know when the litigation is pending. Did you inform him?
Lord, that the simple question, my lord. If I can just show you the prayer that has been sought in this petition, my lord. The prayer so there is a suit that has been filed by the petitioner before the trial court, and the suit basically asks for the relief with respect to certain property which is in, which was I had given to him. The financial institution, LIC HFL had actually given to him. The difficult,
Means how you given to, how you have
my
given.
lord,
to-
through after the SURFACE proceedings, my lord, pursuant to SURFACE proceedings, my lord.
That is, after, he is an auction
Auction,
purchaser.
through auction, my
Have
lord.
paid the full consideration, my lords.
No, he's
Given
expressing
under-
as if.
I'm sorry, my lord, I should have
given
used
him
the
in
right
gift
language,
or
my lord.
something.
It was-
Property was, you auctioned the property,
Yes,
he
my lord.
purchased the property
Yes,
in the
my lord.
auction.
Please, my
So
lord.
precisely that is what the learned
But
judge
that-
has. What is wrong with
I
that?
bow down, my
You are
lord.
expressing as if that some orders are
My
passed
lord.
by learned judge against you.
My lord, if I may, my lord, if your lordship may, I would like to take you to the prayer, my lord, that has been sought.
Prayer in which writ?
In the writ petition, the first 31.1, my lord.
Give that.
28,721 is 31.
Yes.
The prayer is issue a writ of certiorari and set aside the impugned order dated 1/9/2025, passed by the Honorable Additional City Civil and Sessions Judge, in so far as non-grant of the interim order in respect of respondent number 2. So his only relief is that the interim order that was passed by the trial court is not applied to respondent number 2. That is the only relief that was sought.
Respondent number 2.
Lord, respondent number 2 is one of the other defendants.
You
my lord.
represent whom? Respondent number?
I represent
Degree
respondent
holders. There is
Res-
a decree already. There
One
is a-
minute, respondent number?
number 225. My lord.
That's against them.
Yes, my lord.
Mm.
I have purchased the property. There is a compromise decree.
My writ petition.
No, because.
Can I
No,
can
I
I set
have-
out the facts?
Yes,
The facts
yes.
are thus, my lords.
No,
May I-
before you start the
Lord, if
facts.
Your lordship
There are-
permits me for a minute.
Mm.
What I would like to say is, my lord, the suit was filed. The injunction order was not granted. The
Against
petition-
him,
Against him.
one, R1.
Against me, my lord.
Respondent.
It is not
Not
granted.
granted.
Against me, injunction is not granted.
Petitioner has approached this court.
This court has granted now.
granted an order of injunction. The 39(1) and 2 has still not been heard by the trial court. Well, Lord, this court can't give any finding on the interim order granted here because it will
Why
influence.
interim order is granted?
It's given here.
Interim, my lord, against the non-grant of the interim order as against one of the respondents who claims to be a decree holder in execution proceedings.
Injunction is granted against others.
Injunction is granted against others, but he is one of the decree holders. There are 4 decree holders under a compromise decree, of which I am not aware of. There is an execution petition pending. And my lords, I receive a notice after I purchased, I developed the
If
property.
injunction is not granted, remedy is with petition.
My lords, non-grant of ex parte injunction.
Ex parte.
Ex parte
They
injunction.
can
So
consider
it's not a
the-
considered order. It's
How
not
this
at that
court can
stage.
remand back
So
the
I
matter.
go before the trial court,
The
my
trial court
lords,
decide the
where
matter.
the execution petition is pending. And I file a suit, I file a memo saying this matter has to be heard before the same court. And both matters are posted on the same day. I get an interim order. Insofar as the execution petition is concerned, the trial court passes an order saying, by using police force, I should be vacated. So, my lords, when both matters are pending before the very same court, my lords, and in
No,
one
no.
matter,
That's why, please come to this 31.
yes, ma'am.
28722 of 2025 is
Correct.
questioning.
In this, the non-grant of the interim order as against the respondent numbers,
R1.
all, not only R1, my lords.
Mm.
My lords, 27, 37, which one? 28721. Where is the list? Lords, in 28721.
First
28721.
is 28722.
First 28722, my lords. In 287.
What is the prayer? Come to the prayer, let me see.
In page number 78, my lords.
Prayer is it? Prayer will
No,
not
sorry,
be at issue writ
In
so and so.
this case, the interim order was
So
not granted
far,
at all.
as non-grant of the interim order in respect of respondent number 1 to 6.
Yes. No interim order was granted there.
What
The
is the,
second
what is
one-
the order passed by the court,
By this honorable court, my lords.
by the trial court?
Trial court ordered,
Summons.
yes, my lords.
Just
They were on caveat. They were on
notice-
caveat in one matter, my lords. They were on caveat.
No, that's right. Without going into further confusion, 28722 of 2025. Please, please show the impugned order.
Yes, ma'am.
Lord,
Only notice, the
Page-
31(2) has not been disposed of. Only notice
Page
has been-
46.
What is the impugned order?
Page 46.
Impugned order is at page number 44. Page number 44, my lords, on 1/8/2025, caveat was recorded. Counsel for the plaintiff filed, page number 46. Counsel for the plaintiff filed memo of documents. Counsel for the
This is
plaintiff.
the
argued
order
that-
according to you.
Yes, madam. So there was a caveat, and thereafter matter was posted for filing of the written statement. On the day when it is set out for written statement in the execution proceeding, this very same court passes the order on the day the written statement is filed, that
So,
I should be
no,
forced out
you have an injunction by this court.
by this honorable court.
Without even recording any findings of all that, which is generally are required to be done.
My lords, there is no interim order granted by the trial court, my lords, as against these respondents.
I will send all these matters to the trial court. Let the trial
That
court
would be my
decide.
prayer, my lord, for consideration
trial
of the interim
court,
order.
let the trial court decide everything, because while granting I'll also record that while granting an order by this court, what is required to be considered under an order 39 rule 1 and 2 are not considered by the court. So uninfluenced by the order that is granted by this court, the court should independently deal with the application in accordance with law.
My lords,
Please-
while
please,
granting
madam.
the interim order by this honorable court, my lords, the aspect, both of these properties are purchased under the auction from banks. So in one of it, the order was recorded.
Because uninfluenced by any of the
Yes,
observations.
ma'am.
Please,
Let
The
it be.
court should decide that.
Because this honorable court did consider at that stage what
My
the
lord,
scenario
my
is.
lord.
So uninfluenced, the matter can go back to trial court, my lords.
Please, madam.
My lord, may I make submission, madam? The statement that he has purchased the property is,
No, I am
no, only, my lord, I will not.
Because all those are not necessary.
Yes.
I am saying, I am not going into, only now the order is, court has not granted interim injunction, he has come, this court has granted.
Yes.
What I am saying is, whatever the reasons that are recorded by the court while granting injunction, none of them should be considered by the court independently on the merits of the matter. That application for interim injunction shall be considered within a period of 2 weeks from the date of receipt of this
Stage
copy
of
of the
notice
order.
is not complete
Huh?
there.
My lord,
Stage
my
of
lord,
notice is
that-
not complete.
No, you're seeking,
Huh?
1 minute, you're seeking injunction
Yes.
against whom? Whoever are there, whoever
Yes.
are the parties
Whoever are the
now,
parties. There.
let that be
Yes.
heard. They are there.
My lord, there is a catch.
as
There
I-
is a catch for this. Sorry to say this.
I have
My-
no objection, my lords, for it to be heard by the trial court.
Please permit me to say at least 2 sentences or 3 sentences. My lord, way back in 1999, there is a decree, my lord, in my favor. A suit for specific performance was
Auction purchaser, my
One
lord.
second.
I have paid 5 crores
No.
in auction to them.
But
My lord, did
unfortunately, either of your submissions, I'm not going to record in
Yes,
the
yes,
order.
yes.
So
No,
in that case, why should we even
No, only-
dwell on this for even a
I
minute?
bow down to my lords.
Bow down.
It has to.
no,
It has to be
we
heard
are,
by the trial court.
all of us bow down to the court only, my lord, but fact of the matter is only this. I am not saying anything against the order or in favor of the order. 1999 is the compromise decree. And after the compromise decree, the sufferer of the decree sells the property and it is purchased, and the bank has auctioned that property to somebody, that is the petitioner. And I have stated all this before the court. Therefore, after going through the records, court found that respondent 2 to 5 herein are the purchasers of the property they have a decree in their favor in the year 2000, and there is a sale deed. And subsequent, the very prayer of the petitioner in the trial court is,
They say there is a sale deed.
1 second.
Sale deed is not even registered to this day. They get a court sale deed
Compromise is the
executed.
mortgage.
If
My
you
lord,
take the
it is-
income certificate, the
My lord,
sale deed is not reflected. I don't know.
I did not interject when
My
when
I
they,
have not even
to all
started
of you
my
is,
submission,
my
madam.
request to all of you is, when hearing the arguments of the council required in the facts of the case, I'll hear.
Yes,
No,
ma'am.
I'm not even looking into any of the papers. I'm not making any observation. So why should we waste the time? I'm not recording not even one submission of his. So if I hear your submissions also, how is it going to change? Because I'm not recording. Please come. WP number,
Lord.
common order.
in that view of the matter, this honorable court is giving a direction to the trial court to dispose it off within a time bound.
IS.
Yes,
IS.
my lord.
IS
Yes.
only.
Yes,
Yes.
yes.
WP number
First one.
28722 of 2025 and WP number 28721 of 2025. The writ petition is filed, seeing the following prayers. A coordinate bench of this court had passed an order in WP number 28721 of 2025, dated 19/9/2025. Please extract that order. The vacate petitions are filed by the respondents.
As well as this matter. Even in this matter, similar order is passed.
Date
Same
and
day.
a similar
Both were
order-
listed.
Similar orders are passed in both the writ petitions on 19/9/2025. The respondents have filed their vacate petition. Both the petitioner as well as the respondent, you appear for respondent 2 to 1 to?
2 to 5, my lord.
Respondent 2 to 5.
No, 2 to 5 in 28721.
What is, you're arrayed as originally in the, you are the
I was
He's a dependent
key
number.
holder.
I
Decree.
was
He is the-
carried as dependent number 2 to 5 in
He's
the, yes,
Defendant number 2 to 5 in the suit and the.
in the suit.
In the suit. Land counsel, what did you write before this? What did I say before this? Land counsel appearing for defendant number 2 to
5.
2 to 5 has filed the vacate petitions. All the counsels have made certain submissions on the merits of the matter. This court is not inclined to go into any of those aspects for the reason when an ad interim injunction was not granted and suit summons were issued, the petitioner has come before and basing on submissions made by the petitioner, an interim order was granted by a coordinate bench of this court. In the light of the in the light of the dispute that is pending between the parties and parties which requires a deeper inquiry and basing on and the court can only consider these applications for interim injunction after giving a reasonable opportunity to all the parties concerned. This court deems it appropriate to remand the matter to the trial court. The trial court shall consider the application on the merits of the matter, uninfluenced by any of the observations made by a coordinate bench of this court in the order dated 19/9/2025, and shall give an opportunity to the parties and pass appropriate orders. Accordingly, this court is passing the following order. The writ petitions are disposed of directing so and so court to dispose of I number
2, 3 and 4.
I
in both
number
the
2, 3 and 4 in accordance with law within a period of 2 weeks from the date of receipt of the copy of the order, and the court shall not be influenced by any of the observations dated 19/9/2025 and shall consider the same in accordance with law. Number 3, parties are at liberty to advance their arguments.
My lord, the parties may
The
be
interim order
direct,
may be continued, my lord, sir.
my lord, parties may be directed to appear on a particular day.
Parties.
All the parties, my lord.
All the
All the
parties
parties
shall appear before the court. All the parties means all are not served.
My lord, all of them are here now.
Whoever is here is served. There are other respondents, which is the mortgage.
No, as far as the injunction is concerned.
Injunction is
Who are the affected parties?
These are the parties.
All the
These are the
affected,
parties.
all the affected parties are before the court, though there are some respondents who are not served. In the interest of justice, this court deems it appropriate to direct the trial court to decide the applications in the presence of the parties who will be affected by grant or rejection of an order of injunction. All the parties, number 4, all the parties who are before this, who are appeared
Yes.
to advocate
Yes,
before
madam.
this court shall appear before the trial court on 6th of August.
Please, madam.
2 weeks from 6th of August, the court shall dispose of the application. The interim order that is granted by this court, as it is operating from
19/9.
19/9/2025 shall operate till the cases shall be enforced till the application is decided.
Greatly
Please, my lord.
obliged to the court.
Greatly obliged to the court.
That's why what, in all the present matters,
Yes.
in none of the matters where suit summons are issued, I'm not granting any interim order, because if 1 year it's on IA, if the cases are pending, when
Yes.
will the main matters be decided?
And the intricacies.
No, but ultimately it may not be, it may not go well with the advocates because they're getting interim orders here. I'm not granting, but in the interest of
Yes.
litigants and in the interest of institution, that is right.
Obliged.
May not be in the interest of advocates. Yes, next.
My lord, I'm for the petitioner, short pass over, my lord. Senior is on legs in the another court hall.
This matter today, I'm raising it, I have to, I can't take up the matters today.
We'll address the arguments, my lord, because the direction from the Supreme Court to dispose the matter within a timeline of 6
Monday, my
months.
lord.
No, we'll
And
address
the
the
proxy
argument. The senior
counsel for
counsel
the-
is in his legs.
Mr. Counsel, I'm saying I'm raising today early. I have to go to the Harvard bench. That's what. So you say that no, we will argue the matter. What is it?
I'm sorry.
This is matter on 5th of August.
Grateful.
My lord, on top of the list, my lord.
The 5th of August in the first list.
Appearing for petition. In this case, my lord.
There is an interim, what is this you have given?
My lord, in this case, my lord, your lordship.
Yes, interim order only granted is extended.
My lord, there is.
No, my lord, the Sam court, my lord, dismissed my writ petition.
I will not grant any time.
ಅಲ್ಲ ಟೈಮ್ ಅಲ್ಲ ಇದು ಅಪೀಲ್ ಹಾಕಕ್ಕೆ
No, just no injustice.
ಅಲ್ಲ ಅದು ನಾನು
I have to be convinced.
ದಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಪಿಯರಿಂಗ್ ಮಲಾಡ್ ಅದು ಕಮೆಂಟ್ ಸೆಪ್ಟೆಂಬರ್ ಇಂದ ಕ್ಲಾಸ್ಗಳು ಕನ್ಸಿಟಿ 2 ಬ್ಯಾಚ್ ಇದಾವೆ 200 ಹುಡುಗರು 200 ಸ್ಟೂಡೆಂಟ್ಸ್ ವಿಲ್ ಬಿ ಎಫೆಕ್ಟೆಡ್ ಮೇಲೆ ಓನ್ಲಿ ಫಾರ್
Which is the department?
that's
We'll ask.
Nursing college, my lord.
No, we'll ask the AGA to get instructions in this. What is that college?
please madam
I will pass on the photographs, my lord.
No, we'll ask the AGA.
please madam
He will get instructions.
Recent photographs.
Please take that.
Lord, in the Google itself it is also there that
No, Google
notification
not required. Yes,
no my
Mr.
lord in
AGA.
the Google
In respect of this, give these papers to him.
Please, ma'am.
Karnataka Nursing and Paramedical, what is this college name?
college name is Gnanesh Institute of Nursing
Gnanesh?
Institute of Nursing
Other particulars, Gnanesh Institute of Nursing at which place?
Gnanesh survey number 29/1 Sonnenhalli Kengeri Hobbli Bangalore South Taluk Bangalore my lord.
Where do you get the address?
Address in the petition itself my lord, caste title in the caste title itself. This is Gnanesh Institute of Nursing.
The learned AGA shall get specific instructions.
I will also furnish
Whether
the
any permission is granted to Mrs. Gnanesh Institute of Nursing, number 3, survey number 29/1. What is this? Sonnenhalli, Kengeri Hobbli, Bangalore South, by the government. If any permission is granted, how many students are there in the said college?
Shall I make one submission, my lord? Kindly look into the photographs of the present status of the place.
That's what we'll ask them.
Just once, my lord.
No,
Once.
if I look at it, he'll say that it is not correct.
It's all right, my lord.
We'll ask him. He'll come up with.
Yes, my lord.
Learned AGA shall get specific instructions from the concern with regard to this, as it is a case of the petitioner that he is running a college and now in view of the eviction. Yeah. I'll ask him.
I will furnish the copy now itself my lord.
As
With petition and also
as he is running a college and his case and his suit for eviction, the suit for eviction filed with the respondent is ordered by the court, and this court has also dismissed his CRP. He seeks time to vacate the premises or oblique till he approaches the honorable apex court. Learned counsel for the respondent has denied the fact that he is running a college in the said institution. Hence, learned AGA shall get specific instructions in this backdrop. The learned counsel for the petition saw the copy of the writ petition on the counsel for on the learned AGA. Yes. Yes.
My lord, day before yesterday they have obtained police protection order my lord. Till then not to proceed.
Monday. Don't precipitate anything. Don't take any steps till Monday.
Monday.
Monday I'll pass orders. Monday.
Tuesday, my lords. Tuesday. I have to seek instructions.
Sir, you have
Why,
tried
Mr.
again.
AGA, even
Please.
you're a powerful state. Why do you want time like this? Give him the
Please,
papers.
Monday, my lord.
Monday.
Obliged.
In the first list. Yes.
My lord, in this case, I represent the petitioner. My lord, the petitioner is the plaintiff in the suit for ejectment filed by him against the respondents. My lord, in the suit, the specific contention of the defendants respondents is that they are not the tenants under the plaintiff.
Any urgency for this now?
My lord, the urgency is this, the suit.
It on in the month of February.
Correct, my lord. Now, the suit is of the year 2019.
We'll hear
And
it.
in the suit, my lord, there was an order on IA number 1 directing that,
There is no time. I have.
I'll just take 2 minutes, my lord, not more than that. I'll just take 2 minutes. My lord,
Why you have not done anything in 2 minutes from February?
my lord, it has been posted. Unfortunately, it was not reached.
Bunch of order sheet.
Yes,
It has come up these many times.
It has come up, my lord, but it was
Today
not
there is no
reached.
time for me. I'll not be
My
able
lord,
to
a
hear.
date may be fixed.
Yes, this is matter on 11th of August. Yes,
Please.
35 also.
In the list, list 1, my lord.
135
Please,
also
much.
on 17th of August. 36 also.
My lords, it's a suit of the year
2004 matter, my lord.
2004 suit, my lords. A short date may be given, my lords. It's a very
The
short.
matter on 5th of August.
Please, my lords. Interim order may be extended.
In all that, wherever interim orders are there, extra. Yes, 37.
Appearing for the petitioner, my lord. It is a suit for injunction, my lord.
It's coming up for the first time?
Yes, my lord.
Yes, this is matter
Interim
on
order
Monday.
is there, my lord, in
Monday,
February.
Monday. Flesh
Interim
matter
order
on
may kindly
Monday.
be extended, my lord.
38.
My lord, it is not, after 2 weeks, my lord, there is an interim order in their favor, my lord.
You have an interim order?
Yes, my lord.
Yes.
Why it is listed again then?
B group, it is listed in the B group, my lord.
37. List is matter after 2 weeks. Interim order earlier granted is extended.
Please.
Yes, 38.
38, it's only for the recasting of issues. Any short date may be given. I had not sought for the interim order because it was only a short
List the
date.
matter on 12th of August.
Please, Milot. On the first list, Milot.
First list.
Great.
Yes, 39.
39 is also regarding the issues, my lord, which I am seeking for the formulation.
Yes, list is matter on 13th of August.
In the first list, my lord.
First list. Is 40.
I'm appearing for the respondent, my lord. There is a misuse of tariff, my lord. The alternative remedy is available for the appeal before the appellate authority, my lord.
Give that. What is the?
My lord, what is under challenge, my lord, is an order of back billing. My lord, kindly have a look at
You
page.
have an alternative remedy for that.
Lord,
Yes, my lord, alternative remedy is available. Annexure D, my lord, may kindly see the annexure D, my lord, misuse of tariff, my lord. They have alternative remedy available, my lord.
When you have an alternative remedy, why did you come here?
My lord, why? For this reason, my lord. My lord, this is a petitioner, is a charitable trust. My lord, in the year 2009, my lord, already similar order of back billing was issued. Then, my lord, this very same assessing officer, my lord, he reversed the bill, back billing, my lord, saying that since this is a charitable trust and this trust has got exemption under the Income Tax Act, my lord, I am entitled to be levied only under domestic tariff. The very same officer, my lord, he reversed the bill. Now, that is in the year 2009. Now, my lord, over a passage of time, again, my lord, the same officer passes one more order, back billing about 14 lakhs. No doubt, my lord, I have got a alternate remedy, but my lord, there is a condition that, my lord, I am bound to deposit 50% of this back billing amount.
In every statutory appeals, that is what is there. Yes. On the merits of it, what are your submissions? Yes.
I'll file my objections regarding the, there is alternative remedy, my lord.
You have to have some instructions. That's how the papers are served on the respondents to for whether he is entitled for an interim order or not. That I can be able to decide basing on your argument now, not objections. Objections you can file.
My lords may kindly see the page number 28 of the, my lord.
Take up this matter on Tuesday. By Tuesday, get instructions and.
My lord, Wednesday, my lord, Wednesday, my lord.
Wednesday in the first list.
My lord,
Much
in the preliminary hearing, my lord.
First list.
Very well.
Yes.
Grateful.
Listed for preliminary hearing. Yes. 41.
41, my lords, I beg to appear for respondents. They have been not appearing for quite number of occasions.
Let's see that.
Occasions appear.
I think with this, why is he not coming to court? In other matters also, I've seen a couple of times that he didn't appear. Lokesh Kumar.
I know him. In fact, I see him occasionally.
Comes to the court.
He comes. He
regular?
comes.
Other day also in some matter he filed a caveat and he didn't appear. After giving 2-3 chances, then I passed an order.
I will inform him, my lords. I have his number. If your lordships can repeat, I don't want to get a dismissal order in his absence.
Yes, because it's
If
always
it can be
good that we
relisted on
pass orders.
Tuesday or Wednesday, I will inform
Finally,
him.
list this matter on Wednesday in first list. Then counsel for the petitioner, then counsel for the respondent shall inform the counsel for the petitioner.
Tuesday or Wednesday?
Wednesday.
Wednesday.
Yes.
Obliged.
Next. This is 42. Yes.
Your Lordship, the insurance company agreed by the order passed by the Commissioner for Workmen's Compensation had filed an appeal. As statute mandated, we deposited the entire award amount of 3,76,740 before this honorable court as per the practice which was prevalent then, Your Lordship. Annexure D, our MFA, Your Lordship, is numbered as 1098 of 2012, Your Lordship. Annexure D. When we have deposited that, by mistake, from the account section, they have transferred that amount into 1098 of 2011, Your Lordship. So we moved an application before this honorable court, which are at annexure E and F. And this honorable court on our application has passed the order as per annexure G, Your Lordship.
Page number.
Perusal of the office note would indicate that the amount in deposit has been wrongly deposited.
Number.
Yes, I'm sorry. Page number, Your Lordship. I'm sorry. It's annexure D is page number 29, Your Lordship. Annexure G is page number 33, Your Lordship. This honorable court on our application, when we found that despite our deposit, it is not indicated in the order sheet, we moved an application as per annexure G and E and F. This honorable court had directed the concerned section people to put an office note. And it is found by this honorable court that perusal of the office note would indicate that the amount in deposit has been wrongly deposited in MFA 1098 of 2011 instead of 2012, Your Lordship. Therefore, this honorable court also directed amount in deposit made by the appellant has to be transmitted to senior civil judge JMFC additional Chiknayakanalli in MVC so and so, and the same may be transmitted to the labor officer commissioner for workmen's compensation Hassan. That is our case, Your Lordship. Despite this order, that amount has not been transferred to the trial court. Meanwhile, in the year 2023, Your Lordship, as per annexure H, our appeals came to be dismissed by this honorable court, and this honorable court has directed the section people to transmit the amount to the concerned tribunal. But since it had gone into a wrong this thing, Your Lordship, now they have filed an.
What is the amount they are entitled for?
Now they have with interest 10 lakhs 34,944 rupees 36 paisa they have now claimed. And Your Lordship can kindly.
Please understand. What you have to answer to the court's query.
Yes.
2021, you deposited an amount of rupees 3,76,000.
Not on 21, Your Lordship. We deposited in the year 2012 itself. 13/4/2000.
No, this calculation is only interest on that amount.
Yeah, no, including that also 3,76,740 plus interest on that
comes to
10 lakhs. They have even annexure.
Court has not enhanced the money.
No, Your Lordship. They have just dismissed our on liability we had challenged. Our appeals have been dismissed as per annexure H, Your Lordship. So we were under the impression that since we had moved an application also and the honorable court directed for rectifying the mistake, we kept quiet. We are only when we received the notice from the execution court, we came to know that it is not so. Then on 14/7, we have filed just to wakalat and prayed for time to file all the details. Without
now this amount where it is lying, we don't know. Now
it is before this honorable
they will
court.
not be entitled for all this interest now.
Your Lordship, but they will be. This honorable court has to decide that, Your Lordship. We have deposited that amount. That amount is still lying before this honorable court only. I have moved. I have prayed that also to call for the records.
You are a judgment debtor.
True, Your Lordship. We have already deposited.
You need to follow it up. You just can't keep quiet.
We have followed it up, Your Lordship, and this honorable court, as per annexure G, has passed the order also.
After that, you have to follow up. That's your duty.
Account section, we don't have any.
If it is not happening, then you have to bring it to the notice of the court that in spite of an order, nothing is happening. You just can't keep quiet, and they can file an execution. They have filed execution.
True, Lordship. At least
Ultimately, how the claimant is concerned with all this.
Your
Claimant
lordship,
wants his money.
I do understand, your lordship. There is, I hope
No,
my
I'll pass
lordship will
I'll
understand
pass
our
an interim
pathetic
order.
situation.
I'll pass an interim order. What will happen to the claim? Again, for another 10 years, this will be here.
No, your lordship, your lordship may pass an interim order. Till then, they appear before this honorable court, and meanwhile, your lordship can call for the records, and I will also have a word with
Should we call for the records?
not records from the trial court, your lordship, so records from the accounts department, how it has happened, and despite the order being passed by this honorable court in the year 2020 itself, why it has
Will
not
not
been.
pursue it. Now this court will pursue
Your
it.
lordship, we have tried our level best, your lordship.
That
Certain
should be,
things
that we should see from some paper.
that we have.
That is in 2021.
Your
After
lordship.
5 years, what are you doing?
Your lordship, since the we have obtained that order copy from this honorable court also, we cannot interfere with the administrative work of this
Does
honorable
it
court,
amount
your
to
lordship.
interfering with administration of our?
Because they may say.
Doesn't amount to, that is your right.
No, because your lordship, despite we having.
You file a writ petition, then because that is registry's administration, you will not ask for a listing of the matter. Or you will not ask for anything.
No, probably your lordship, your lordship is right.
Your people are, because that is not somebody's problem, claimant's problem. So your officers are least bothered.
Your
Now, when it
lordship,
has come to them.
if that were to be the
No,
fact.
If that, now it has come to them by attachment of, what is the order passed now?
Now attachment of mobiles on the very same day when we have filed wakalat. We prayed for time because we had already deposited in the year 2012 itself. And since it was not indicated in 2019, we moved application before this honorable court. And this honorable court passed order in 2021.
You pay them money, whatever it is from there, you can,
Your lordship,
you will withdraw it. Why should he suffer for whatever the difficulties?
Your lordship, I just need a breathing time to at least verify that.
I
Your
will
lordship.
say,
Yes,
you
sir.
deposit the amount, From the court, we'll see that.
But the interest, your lordship,
We
interest.
will see that the trial court will see why this court will look into all that. Now you are only on the question of attachment of mobiles.
Yes,
What
sir.
is the amount payable and all the trial court will decide. First of all, you deposit the amount.
Amount of how much is the problem, your lordship? Because
No, first
our
of all,
liability, our liability,
You deposit this amount. You deposit.
3,76,740.
First you deposit that. And remaining amount we will see. On that condition, I'll grant stay. And in the meantime, we'll order notice and also we'll find out from the registry what has happened to this money.
Yes, your lordship. 3,76,740, your lordship.
First you deposit
And
that.
may I request, your lordship, at least the trial court should give me us an opportunity because the check has to come from the head office.
No, it is, I'll grant the time of 3 weeks for this.
Yes, your lordship. Yes, your
Then
lordship.
they have to come here.
Yes,
Then
your lordship.
then only now the stay is granted, so
Yes.
nothing can be done. The petitioner,
But to take out the check, I need minimum 10 days time because it has to come from Chennai, your lordship. That is my problem.
3 weeks.
Oh, yes, your lordship. Yes, your lordship.
The petition is before this court. Agreed with the order passed by the court, where in the execution for attachment of the mobiles, it is a contention of the land council appearing for the petitioner that, in fact, they have deposited the amount before this court in the year 2012 itself. But instead of depositing it to the account of the MFA number 1098 of 2012, it is deposited in 1098 of 2011.
We have, there is no mistake on our part.
Account
Yes,
office,
yes, yes.
instead of to that account, it is submitted that. In fact, in the year 2021, they have brought this to the notice of the court and an order was passed on 25/11/2021. In spite of that, the amount is not transferred to the trial court. And now the executing court, without giving them an opportunity, has ordered for attachment of mobiles. Considering the submission of the land council for the petitioner, they shall be stay of all further proceedings on the condition that they shall deposit 3,76,740 within a period of 3 weeks from the date of receipt of the copy of the order. Notice to respondents. The petition is permitted to take out hand summons on the council appearing for the respondent before the trial court and shall file a memo to that effect by 17th of August, or else the stay granted by this court stands vacated. Next point. The registrar judicial is directed to verify with regard to the order passed on 25/11/2021 in MFA number 1098 of 2012 and whether this amount is transferred to the trial court after the appeal is disposed of or not. a report shall be placed before the court. List this matter on, your 3 weeks will complete when? Today is?
20th or 21st, Your Lordship, of August.
List the matter on 24th of August.
Obliged, Your Lordship.
Yes.
The petition. The office objection is, I filed a single writ in respect of two applications.
What
That
are
is
the two
recall and reopen the case.
This objection with regard to the maintainability.
The other
of the-
objection is, I have made somebody,
Maintainability on two IAs is overruled. And the other one?
the other one is JDR 5 is deleted by the trial court order. I have still made him a party. That is the other office objection.
Then why should you make him up?
I will, in fact, I have made a note to dispense
Teacher
notice.
shall comply with the other office objection.
Please. My lord,
Yes.
DHR is served this year, my lord.
You're
What
the
I'm,
aviator?
please, my lord.
Yes.
What is under challenge
Paper,
is
sir?
an application. Yes, ma'am.
Yes.
What is under challenge is an application for rejection of the application to cross-examine DHR witness.
Come to the impugned order straight away.
Impugned order, I am producing it now, my lord, because the order was not available as on the date of filing of the petition. I have obtained it this morning.
Couldn't have filed this also.
My lord, the
You should have
difficulty
been
was,
physically present and should have asked for it.
no, my lord, the
Take
difficulty was today morning.
that order.
Please. My lord, the background is this: in the execution, a coordinate bench.
No other facts are required. Let me look at the order.
Please, ma'am.
Then any submission.
Please.
Come to the reasoning part and start reading it.
Please, my lord. As per the order sheet dated 15/7/2026, the decree holder was present. Her evidence affidavit was filed. It was treated as examination in chief of RW1. Exhibits R1 to 26 were marked. Advocate for JDR sought time for cross-examination of RW1. Since it is a time-bound matter under the High Court directions, the cross-examination of RW1 was taken as nil. On the very next day, JDRs 1, 2, 4, 6 to 8, I represent 7, my lord, filed these applications claiming that their representing counsel needed time to examine exhibits R1 to R26. However, these exhibits were not produced by surprise, as those documents had already been produced at the time of filing the execution petition. There was ample time for the judgment debtors or their counsel to examine the documents and prepare for cross-examination. Page 7. This is a time-bound matter pursuant to the directions issued by the Honorable High Court of Karnataka in writ number 34575 of 25. The said direction was communicated to this court on 1/11/2025. After assuming concurrent charge of this court on 6/6/2026 from the previous presiding officer, I examined JDR2 as PW1. Subsequently, JDRs 4 and 6 to 8 were examined as PWs 2 to 6 on 6/7/2026. A perusal of the order sheet reveals that the judgment debtors are in the habit of filing successive applications. They had previously filed IS 16 to 25 under similar provisions seeking extension of time to adduce their evidence. This court considered those applications sympathetically and allowed them. Now the judgment debtors have filed the similar application seeking permission to cross-examine RW1, which cannot be permitted. Instead of complying with the time-bound order of the Honorable High Court of Karnataka, judgment debtors are indulging in dilatory tactics. Therefore, they are not entitled to any further
Where is
sympathy.
your affidavit filed in support of this?
My lord, may I point out one circumstance, my lord? At page 7,
Where is the affidavit in support of this IA?
affidavit in support of the IA is at page 128. But there's only one factually incorrect observation made by the Honorable Trial Court.
Let's see this 128. What did you say? Why
Please,
do you
my
want?
128, my lord, the relevant portions might be at page 129 from para 4, my lord.
When was the execution filed?
My lord, the execution is filed in 2023, my lord.
Yes. What about the examination? Whether the
Why
cross-examination-
examination was necessary was pursuant an order passed by the coordinate bench of this honorable court, which found that an inquiry was necessary into the objections because I was not party to the original decree at all. Since I was not, these judgment debtors were not parties to the original decree, their objections will have to be heard was what we contended. The executing court said, yes, an inquiry is necessary. That order was challenged by the decree holders before this honorable court. This honorable court confirmed the order saying an inquiry is necessary. That order is at page 101 of my writ petition, my lord. And in that writ petition, a direction.
Order was dated 31/10/2025.
No, my lord. That is the mistake committed by the trial court.
What is the order? No,
this-
that is not the court's. Come to page 129. That is your affidavit.
Please, my lord. That is the order passed by the trial court. Now
Yes.
on
High
the
Court
memo.
order is when?
I'm sorry, my lord.
When is the order of the High Court?
The order of the High Court is on 25/3/2026, page 101, my lord.
25/3/2026.
That was communicated to the trial court as per the order sheet on 2/5/2026. 6 months from then, my lord. I have produced the order. That is at page 101. The operative portion is at page 114.
He'll ask him to conclude it in one day instead of
And-
wasting all this.
That was the submission I made to the.
Since it was a direction matter,
That's what I'm saying.
Please.
We'll not, we'll say, when the matter is coming tomorrow, let them be
I
permitted
will
to
cross-
cross-examine so and
Please.
so. He shall not
Please.
seek any time and it should be concluded tomorrow itself.
please.
Please, madam.
It's good for both of you.
Please, madam. That was the submission made.
Only, my submission is only with respect to this judgment data, it may be
Very
allowed, my
well.
lord.
Only this judgment letter
Please,
is
please.
before the court.
Yes, yes.
Please, my lord.
Whosoever.
And a direction may be issued that let them complete the cross-examination on the same
Lordship,
day.
may record my undertaking that in fact, it was submitted that I will cross-examine on the same day.
Only this person is agreed by it.
Please, my
Only R,
I am judgment debtor 7.
D7. Yes,
Please.
only as far as D7 will confine it.
please, my lord.
The petitioner was arrayed as D7 in execution petition number 691 of 2023 before the 39th edition City Civil and Session Court, Bangalore, in execution, Bangalore, is agreed with the order dated, date of order is
Date of order is 28/7/2026.
28/7/2026, whereby the court has refused to reopen the stage of the respondents to recall RW1 judgment debtor and to recall.
RW1 is DHR number
To
1.
recall RW1 DHR. The court has dismissed this application on the ground that earlier in fact, the application is filed on behalf of how many? Who have filed the application?
My lord, all the
This
JDRs.
That's what I'm saying. Who are?
This application is filed by JDR 7. Other applications were filed by JDR 1, 2, 4, 6.
Applications IAS number 26 to 37
Please.
were filed. In that, IA number,
26 and 27 are pertaining to this JDR.
IA number 26 and 27 are filed by the petitioner before this court, were JDR number 7.
Please.
The court had dismissed the application, all the applications on the ground that this is a case where the High Court has given specific directions to dispose of the matter in an expeditious manner. And these are the consecutive applications that are filed by the judgment debtors, and hence the court finds no reason to reopen and recall RW1, that is a judgment debtor, for cross-examination.
My lord, decree holder number.
Decree holder for
Decree
cross-examination.
holder number 1.
Decree holder number 1 for cross-examination. Land counsel for the petitioner submits that there is no intention on the part of the petitioner to petitioner judgment debtor number 7 to delay the proceedings. It is only for the High Court order was passed in the month of March.
25/3/2026.
25/3/2026, and immediately thereafter they have filed an application. It is submitted that if one opportunity is given, he'll complete the cross-examination and they will not delay the proceedings. Just because the matter is directed to be decided by the court in a time-bound manner, that does not mean that a reasonable opportunity will not be given to the petitioner and it will defeat the ends of justice. The decree holder has filed the caveat, and the submissions are made on behalf of the caveator. It is submitted that the court has rightly considered and rightly dismissed the application as it is mentioned by the court. It shows that how many times these several similar applications were filed, and in spite of that applications being allowed, again the judgment debtors are coming up with one application or the other, and there would not, if these kind of applications are allowed, there will not be any end to this proceedings, and the order of the court cannot be where there is a direction cannot be complied with. It is submitted that the writ petition may be dismissed.
Lord, in fact, the decree holder number 1 is 75-year-old woman. my
It is
lord, so
submitted that the age of the decree holder is 75 years.
maybe-
And because of these delay tactics, the decree holder could not enjoy the fruits of the decree
Please, my lord.
till now. Next para, having other counsels on either side, there's a material on record. The court has recorded the reasons for dismissal of the application. It is a submission of the learned counsel for the petitioner that only in one opportunity is given, he'll conclude his evidence, considering the interests of the parties and balancing the interest, and looking at the substantial justice and balancing the interests of both the parties, this court deems it appropriate to grant an opportunity to the petitioner judgment debtor number 7 to cross-examine RW1, the JDR, the decree holder number 1. Accordingly, this court is passing the following order. The writ petition is disposed of. The order impugned dated so and so. As far as I number 26, 5 and 6.
26 and 27.
26 and 27 is set aside, and the petitioner, JDR number 7 is permitted to cross-examine the decree holder number 1 on.
My lord, I'm told 5-8 is convenient.
5-8, my lord.
On 5.
5-8.
On 5/8/2026. And number 2, it is made clear that no further time shall be granted if on the day, if the JDR number 7 fails to cross-examine the DHR 1, the court shall proceed with the matter in accordance with law. And for 3, the judgment debtor number 7 shall cooperate with the court for the early disposal of the case.
I see. My lord, notice to R3 to 10 may be dispensed with. They are co-JDRs.
Memo
I
is
will file a
filed.
memo to that.
Memo is filed seeking dispensation of notice to
3 to 10 respondents.
3 to 10 are they are the co-JDRs. Yes.
My lord, threatened electricity disconnection.
Hmm.
The impugned order, my lords, is in Kannada, my lords. My apologies. It's at page 23.
Have you served at least the counsel someone who appears?
Lords, we filed it only this morning, therefore I did not have, my lords, the time. The short facts, my lords, are, your lordship may, my lord, kindly protect
It
me.
is
till-
like making the court, compelling the court to pass some order today. Now, generally in all this BESCOM matters, without hearing the instructions of the respondents, I don't pass any orders.
I bow down, my lords. Your lordship may protect me till Monday, I'll serve them. And your lordship may, my lord, call it on Monday or Tuesday. There is a NCLT proceeding. I purchased the property under
Land
NCLT
counsel
option.
appearing for the respondent submits that the respondents are going to disconnect the power supply. What are you doing from 14/7/2026?
Lords, I got wind of these proceedings on 27/7/2026. My lords, in once, I am auction purchaser. I moved the NCLT saying past dues I am not required to pay. The
Please come,
NCLT
it
held
is
in my.
submitted that the respondents are going to disconnect the power supply. The proceedings are 14/7/2026. Yes, he could get those proceedings only on 27/7/2026, and immediately has approached this court. Generally, in these kind of matters, without notice to the, without any instructions from the respondent, this court would not interfere. However, considering the fact that the respondent, the petitioner is a company, and if there is a power, if the respondent disconnect the power supply, it would cause a lot of hardship to the petitioner. This court, hence the respondents are directed not to disconnect the power supply till Monday. List this matter on Monday in the first list as a first matter. Mr. Devraju is directed to take notice on behalf of the respondent. Then counsel for the petitioner serve the copy of the writ petition. Registry shall reflect their name.
But petitioner is a proprietor, not a company.
Petitioner is a
I'm sorry,
proprietor.
Lords. May I make one request, Lords? Lords, that previous matter, the order be uploaded, Lords. Otherwise, the trial court will not act on.
Uploaded on Monday.
Please, please.
Yes.
Grateful.
Lord, connected matters, my lordship has taken part. We have settled the matter, reporting settlement Monday.
Yes. Tuesday.
Tuesday.
Hand delivery of the order.
I don't think so.
Very well. Great.
Anita madam. Anita madam. Anita madam. ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ನಾಳೆ ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರು ಲೋಕ ಅದಾಲತಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡಲಿಲ್ಲ ಅದಕ್ಕೆ ಹಿಂಗೆ ಬಾಕಿ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ಸರ್ ನೋ ವರೀಸ್ ಏನು ಬೇಡ ನೀವಿದ್ರೆ ನಮ್ಗೆ ಫೈಲ್ ಸ್ಟಕ್ ಆಗ್ಬಿಟ್ಟಿದೆ ನಾನು. ಓಕೆ. ಮಂಗಳವಾರ ಜಾಯಿನ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ತೀನಿ. ನಾನು ಫೈಲ್ ಸ್ಟಕ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಬರ್ತೀನಿ ಎಡಿಷನ್ ಅದು ಸಂಗಮೇಶ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ರ ನಾನು ಬರ್ತೀನಿ ರೀಚ್ ಆಗಿರ್ಲಿಲ್ಲ ಸರ್.